Good morning, everyone.
Good morning, Judge.
Yes, Mr. Siminya.
Chairperson, Commissioner Mabena. We have the remaining days of the week. There's an echo, I don't know why. Chair, that's not going to help. Yeah. Chair, we find it fitting that we express our gratitude, appreciation, thankfulness to ICF, to SERI, in no less a measure to the Human Rights Commission. Included in that gratitude, it is directed to MNS and the city who have given their time to assist the Commission to achieve its mandate. We have traveled a little bit, a long journey together, and for that we are grateful. Might I just try and recast where we are? The Commission has discharged its mandate in respect of the first term of reference in relation to establishing all causal reasons for Usindiso's fire, filed a report with the Premier, and this second stage, it is useful that we focus on what the Commission's mandate is, and I go immediately to read what the instrument establishing the Commission is saying the Commission must inquire into. It says under Roman figure 2, 1A, the Commission is to generally determine the prevalence of buildings or immovable properties in this Johannesburg Central Business District, and it identifies Region F, which are being abandoned by the legitimate landlords or owners and taken over by criminal syndicates or other groups, and list out to and populated with tenants who do not have the means to afford other forms of housing without providing basic services such as water, electricity, refuse removal, and sanitation, and paying rates and taxes, the so-called hijack buildings. And it also requires that there must be findings made in relation to that, determine what lessons are to be learned from it, as well as make recommendations that may ameliorate the problem, mitigate it, or correct to the extent that the Commission can make such recommendations. But Chair, Commissioner, it may be helpful to start understanding the context within which the mandate of the Commission is positioned and fashioned. And as we all know that we are going to derive the authority for the mandate of the Commission principally from the Constitution, which is our basic law. in there, the framework is that of Section 26, which gives a right to everyone to have access to affordable housing, a duty that entails within the constitutional provision a limitation that says it is a right enforceable, as the courts have said in our jurisprudence, but that is a right to be realized progressively because of the fiscal constraints that governments would have. Now, perhaps this is where I want to start, that we have to accept that the overarching problem that besets bad buildings, hijacked buildings, I know we're going to have a little tango with Sari about whether that term is appropriate or not. But the overarching angle within which all this conversation must happen is that until such time as affordable social housing, particularly for the city and region F, until there is that solution, there is no answer in real terms. You're going to have an influx of tenants who occupy these buildings through desperation. Our inspections in local has told us that the people in these bad buildings live in outrageous conditions of squalor. The evidence of Matlangwe and others will tell us that the conditions of bad buildings and the living conditions there are inhospitable, intolerable, and are a evidence of an erosion of their dignity which the Constitution guarantees them. And maybe if I start there, Chair, Madam Commissioner, you will see that there is no factual dispute between all of us. So there are no factual contestations that the Commission ultimately is going to have to resolve. There are even no credibility issues because as evidence leader, we move from the premise that we accept the correctness of sentiments expressed by the lay witnesses. It is their cry, it is legitimate, it is proper. We also accept as correct that the expert witnesses and their evidence comes from an informed platform of expertise which they have held. We have absolutely no objection about the quality of the expert evidence that we have had. What we do with them may be a different proposition. But I must also start from a premise that says we would not be using this time to traverse all the hundreds and hundreds of pages of written submissions that all of us have made. We have had an opportunity to exchange those amongst ourselves. We have tried to narrow and react and respond to those that we should and can. So, as I anticipate will happen, we may be bringing a different reflections, inflections on what are common cause facts. We may be taking different interpretations about their meaning, and we may also, in broad terms, agree that there is, as Mr. Brickhill would have used the word, everything seems to be coalescing in agreement amongst all of us. Now, I implore you as a commission to accept that a commission, by definition, people like to call it pseudo-judicial, is simply not that. Yes, we may have the eminence of your presence, Judge, which is unassailable as a constitutional expert and a former judge of our apex court. But that does not render the commission as a judicial instrument. What it is a advisory tool which, in terms of the Commissions Act and the Constitution, reposes with the executive. It is the executive that appoints commissions. They may very well be subject to judicial review to the extent that there may be grounds for it, but it ultimately is an instrument, if you take the various spheres of government, it resides with the executive. It is where the executive is inviting a platform of this nature that will collate and collect the facts, look at them, assess the evidence, make factual findings, recommendations, lessons learned, etc. But what it cannot do is to tell the executive by way of judicial pronouncement what it must do. We have been unfortunate, despite gallant effort, to try and obtain some clarification about what budget allocation is available for the correction, amelioration, mitigation of these problems. And maybe let me use our most recent last witness evidence to say that there is a recognition that these bad buildings, for as long as they're not able to provide free basic services, electricity, water, sanitation, fire risk containment procedures, they remain a hazard and a catastrophe yet to happen. So if we take that evidence seriously, we must come to an inevitable, ineluctable conclusion that people are sitting in situations of imminent peril. In fact, I was disheartened yesterday listening on the radio about what happened to a family of 6 that died in a fire in Ekurhuleni, which gives us an clear evidence that the problem is real. It is life-challenging. It is threat to life. One of the victims, so says the news, is in a very precarious position fighting for her life. Now, you would have thought that South Africa learned when Usindiso happened, but clearly, and maybe with bated breath, people will wait to see whether or not the Commission is able to offer solutions, resolutions, in relation to what is evidently a problem regarding housing. Now, there is a cascading consequence that happens once we know. The inspection in loco has taught us that, per se, most of those who occupy these buildings are occupying them unlawfully. Yeah, out of desperation, out of harshness of poverty, which visits most of them. And that problem is not assisted by the fact that Johannesburg tends to attract people from the peri-urban area, peri-rural area, and results in congestion, overcrowding, and the use of alternative heat once the electricity is cut and once water is cut or once sanitation is not available, once we occupy buildings that are not designed as residential buildings, then we know what cocktail and what perfect storm we are brewing for a calamity no different than that of Usindiso. So, the other area about which there is no contestation amongst us as facilitators for this commission and the players that is SERI, players that is human rights, player that is MNS in the city, there is also no, I'll use the word prevarication, relating to the status of the law. Nobody has suggested, as far as we have been able to determine, nobody has suggested that the Water Services Act is for one or other reasons irregular. Nobody has contested the fact that the policies in relation to bad buildings, the bad building strategy, the I-chip, nobody's contesting that those policies are not appropriate or are open to legal challenge. What I suspect SERI and others will say, and maybe the city will retort, is that the city is not living good to its own policies. That's as far as that argument can go. So what we are saying as evidence leader, Chair, Madam Commissioner, is that no case has been made out why any of the statutes relevant to housing, why any of the policies relevant to housing is in itself open to legal challenge. Nobody's making that argument. And I don't think there would be a proper platform for the Commission to find any of these policies, any of these administrative processes to be unconstitutional in one manner or another. And that leapfrogs me into discussing, for instance, by way of illustration, the question of how affordable, how ESPs, expanded social packages for provision of water, electricity, and other services, is administratively structured. I don't hear anybody suggesting that it is unlawful to the extent that it seeks to provide qualifying criteria, including the fact that you have to be a South African citizen to access that facility. Nobody's complaining that that in itself invites a legal challenge. Where the city also agrees, though, is that in its very formation, it is not providing the results that it seeks to do. And they tell us with uncontested evidence that they're only able to provide that service in relation to water through a registered customer. They must know who it is, whether they qualify, whether they're indigent, and the whole criteria. Nobody has challenged it to be unacceptable. But the city has also conceded that there's no point in having that policy if ultimately it is not assisting those it is intended to assist. So, what can the Commission do about it? We have tried to suggest through other witnesses that were here that maybe the city should explore even engineering solutions. There's no reason if the last witness tells us that at least keep lights on passages of escape on, so that that gives whoever is trapped in that situation with a possible escape route. But so tells us the experts to us that if you're going to use corrugated iron, which is what is being used, if you're going to use curtains as partitions and you're going to use flammable material, paraffin, gas, etc., so says the witness, you must know and appreciate that a conflagration of the nature that affects these bad buildings consumes that building in 3 minutes. So says the expert. And therefore, emergency services, firefighting systems for the city are unable to resolve that problem. None of them will arrive on a scene of this tragedy within 3 minutes. It's not going to happen. So says the witness. You don't even have water with sufficient pressure to move up to the last floor of the building to be of any help. But so says he. Interventions such as a sprinkler may very well help combat the gravity of the problem. But ultimately, you need to have tenement in a building that is compliant and its fire risk containment is sound, even internationally accepted. But, Chair, with respect, no help will arise to tell the Premier that they must get the bricks and fire-resistant doors on each apartment. The evidence was insightful, but I'm not too sure how practically helpful. The expert and SERI and ICF went and looked at a representative example of 4 buildings. We have inspected more than 100. And if you require 3,000 rand per unit to get the sprinkler system working, I suspect the Commission can't make that unless it has evidence that such funds are available. What the Commission can do, which it is competent to do, is to raise the flag. And that gets me to the next subject, which is iChip. A lot of a lot of money, resource, skills was made to provide the iChip solution, which happily went as far as getting a mayoral recognition for its proposed solutions. And we know that that is an effort that started in 2014 and petered out with, I think, the revolving executives in the city of Johannesburg. But as matters fact and as the evidence stands, iChip was not implemented. Little elements of it seems, according to Makola, to have been incorporated here and there. Remington, as a collaborative effort with public-private partnership, is there, it's standing. But there is no point in ignoring the fact that, according to the witness, they have now an accumulated millions of rents that they owe the city in rates and taxes. They've used borrowed funding to get where they are. The reverse correction about that, it increases the value of the property and the rates and taxes they can afford. And they're expected to pay them as an obligation resting on all of us. Let me step back and recall part of the points that we got admitted. And point to the fact that the bed building strategy, it too is implemented partially without consequent address to these bed buildings, because we get back to that evidence where we know that if you go through the correct legal processes, and the head of legal told us the city has every intention of respecting these legal processes, and the eviction orders they get are also constrained by the demand for alternative accommodation of those who are evicted out of them. Chair, Madam Commissioner, you heard that the occupancy in these TAs is at the brim. We can do nothing more in accommodating the plight of those who occupy them. There doesn't seem to be even budget and financial means of getting us there. I might be sounding very, very lacking in hope, but that's the gravity of the problem. Now, let me do this, Chair. We have addressed in our response, final response submitted last week, what we believe are common cause facts. I did not see anybody raising their arm to suggest that those common cause facts are contestable. Of course, in one way, Sari corrects us to say 1 Risic Street there is no court order there, and I think our investigation reveals that the criticism is valid. So we're not complaining about that correction. It seems to be evidence-based, and we accept it. But again, I invite us to go back to where we were, Chair, and say, we underwent a process with the in-local inspections. We tabulated, as evidence leaders, observations that were made in those inspections. We have extracted from each one of them what we think were factual observations that we gleaned in these inspections in local. And we circulated that to all those who assist us. We did not receive a fight about them. And as a matter of law and evidence, we submitted exhibits which also reflects the nature of the building, its location, what factual findings are competent to be made about that building, and what bylaw infractions were seen in respect of each of those buildings. So there can't be any cry if the commission were to find that those reports, which are exhibits, which were admitted into evidence, to which there were no objections in their admissions, can now complain that it does not contain sufficient evidence for the factual findings that the commission must make. So can I now turn and deal with these matters fact to fact? And might I invite, Chair, that you go to volume 4, where you get page 472. If you go to your documents there, you'll get to volume 4. And if you page through it, you will get to 472. And you will get also to...
There is no 473.
Oops.
Volume 4.
It's volume 5, Chair. I beg your pardon.
That should be volume 5.
It is volume 5. I beg your pardon, Chair. There we find paragraph 1525, and that is when we were listening to the expert Willem Solomon relating to the ESPs. And we say that the witness considered that free basic services through ESP would be difficult given the qualification criteria and the practicality of providing these services in multi-storied buildings. Let me remind us, Chair, what the witness told us or had to concede, that as a rebate-based service, and nobody suggested there is something wrong with that. Nobody suggested that perhaps this service can be provided through coupons. There was no such evidence. But to the extent that there may be contestation in our submissions regarding the ESP, we still must come to the end conclusion about the qualifying criteria for access to that service. And as I tried to suggest to the witness, if the city takes on the responsibility of putting sprinkler system in privately owned properties, where does that take you? Because the building next door would have a legitimate expectation, if not a right, to say that they too require that help. So where is the solution in that quagmire? Difficult to see from this distance, Chair. If we go to page 490, we will find even the evidence of witness Matlangu, whose evidence correctly captures the squalor and the conditions of desperate inhospitality that tenants to these bed buildings have to live through from day to day. There is also his evidence about the adequacy, but perhaps more inadequacy, of the facilities that the TEAs are getting. They are not maintained as they should. And the evidence is also true that if you have a bed building occupied by people who on their own evidence concede that they're illegally, they're unlawful tenants, and then you say, you want to give them a relief to discharge what is also admittedly a constitutional obligation that rests with the state and that rests with the city. The question becomes, how do you provide it? So far, I don't hear the answer to that question. And my sympathy and legal sense says something is wrong if it's a facility available but inaccessible. So I think ultimately what we are saying to the Commission is that the city must be forced into looking at creative solutions to this problem. So in the order of hierarchy, we want to suggest that the city must adopt a formal horizon to the resolution of affordable social housing in the city. It might very well be immediately sprinkler systems can work, but it is a solution that has to be seriously investigated and costed. And it must be an adopted frame what is realizable in the immediate, short term, immediate, and long term, even if that horizon is 20 years. But there must be a discernible, auditable track in the ultimate, well, maybe not ultimate, in the progressive realization of of that constitutional obligation it has. And there's no debate, as I say, and maybe Sarah will spend a little bit of time telling us that there is the constitutional obligation that rests with the city, delegated from national, provincial, and ultimately to the municipalities. Of course, we accept that to be correct. And there's no correction that is required about that. I know that Sarah is going to urge all of us that the city has failed in many respects to access funding that is available to it from national emergency housing program. And we have had the evidence, which is uncomfortable, that there are financial years where this money gets taken back to National Treasury because it remains unspent in a particular financial year. And somewhere the city says, maybe this money can be rolled over from year to year. Well, it's not legally competent to roll over anything. The law is very clear. You get your budget through the Appropriation Act. You use your money within the budget. If there should be a cross, what the accountants call a virement, if there should be a virement, it too must be authorized. So there is no movement of discretion in relation to these issues by and large. I think the point I'm trying to drive home is that any solution that is budgetary is going to have to flow within the budgetary constraints where the PFMA or the provincial one or the city one directs to avoid fruitless and unauthorized expenditures. So if we go, Chair, to page 1756, is it? No, page 525. We will get the evidence in paragraph 1756. The evidence of Mokwebu. If we recall his evidence, he testified that Johannesburg Water supplies water to affected communities using stationary tanks and standpipes. This is the type of evidence that we can accept as a mitigating instrument for the provision of water to these bed buildings. But again, there is a qualification to that evidence when it tells us that those people who are in these tenements which are not designed for residential accommodation then have a practicality challenge until such time as each one of them has a meter that they can offer a rebate to. Let me step back, Chair, and say, when we accept, as the last witness also had to concede, that the legal architecture of the provision of services by the municipality to its people operates on a basis of placing those responsibilities for compliance on the owner. If you read the bylaw, they almost always start with the owner shall. The owner shall. But once you accept that legal premise, you must then come to the inevitable conclusion that the tenants who are in bad buildings are not owners. Is it useful that they have committees in there? Yes, it is absolutely useful. Should there be communication between the city and those tenants? Yes, there must be. But you don't have a legal framework to recognize them as entities to which you can place a legal obligation. Our good witness tried to say maybe there can be consideration to adjust that framework to include occupiers. But we know problem with bad buildings is occupiers are very transient in their very nature. There is no security of tenure. I was listening to the witness telling us quite competently that sometimes these batteries last for 2 years. But if people are struggling with food, how do you provide a solution that they must go buy a 3,000 rand equipment? It's not going to happen. And it is worse if it comes from a commission which has no judicial authority to make that happen. But we know it is not an unwillingness to take care of the adverse fire risk associated with their stay. Flammable material, yes. Combustible material, yes. And the expert says that can work. It's just a disaster in waiting. I have tried to address the expanded social package. And for your notes, Chair, maybe you may want to see paragraph 2.2, page 4 in the reply the evidence leaders have filed. I'm not going to be reading it, maybe just for note-taking. We deal with that element as well. We also deal with it in paragraph 2.8. We deal with it in paragraph 4 on page 8 of the reply as well. The next major topic is the iChip one. Chair, maybe can I ask that we take the tea adjournment a little earlier?
Yes.
And then upon return, I will continue.
We'll take a 15-minute adjournment. Thank you, Mr. Siminya.
Thank you, Chair, Madam Commissioner Mabena. I was to deal with what we heard from witnesses such as Zach on iChip. But maybe before I do that, Chair, I need to remind myself that no helpful purpose will be served by trolling all the hundreds of pages that are in the written submissions. The Commission would have an opportunity during the month of June, as the terms of reference as amended tell us, to go through that journey, looking at each and every witness, its evidence, and the implications of their evidence. But with iChip, again, I reiterate, Chair, it would be a grave pity if the city will put to waste the input of the experts in the journey, the input of the city officials in the journey, the input of consultations that have formed the basis of that. And as Zach tells us, even some costing went into it. But if, for instance, I invite your attention to paragraph 155.7 in volume 5, Chair, you will see there that there is even reference
In volume 5, 155. It can
paragraph.
be
Page 47.
page
47.
Page 471? 479, yes. When you go there, you will see, Chair, that there are cost estimates as good as they were when iChip was conceived, in the order of 2 billion. We're going to agitate for a recommendation that would say to the city they have to revisit iChip, reconfigure it, repurpose it, recost it as part of the bigger solution to creating affordable social housing formula for the city. That's what, as evidence leaders, will be agitating for. Of course, it will need some measure of reconfiguration, whether it will also have the benefit of the presidential working group, which we recently had, was established by the president in lieu and in anticipation of the G20 summit to be held in Johannesburg in November of 2025. Well, that is a date yonder to that of the life of the Commission. But we would still urge that when that exercise happens, and to the extent that it can impact and improve on an iChip-like solution, that the city must consider that as a possible point of reference in its reconsideration of iChip. Again, Chair, if we go to the evidence of ZAC, we know that 2 billion must be a different number today and tomorrow if the concept is to be implemented. But it is one that, as we make the proposition, if you have a well-reasoned timeline within which those I think they said 50,000 new permanent homes were conceived within that solution. Yeah. The demand might be more, but with appropriate adjustments, we suggest that should happen. Can I, for note-taking, Chair, say we look at paragraphs 1553 to 1557 in pages 478 and 479. That's the evidence that addresses the question of the iChip. Which will address affordable rental accommodation, which is at the core of the problems about the conditions that yield to bed buildings. I think the estimate, according to witness Makola, which evidence you will find when you go to page 504 and against paragraph 1661, the amount there was set to be 2.9 billion. But we also know from the Constitution that the provision of affordable social housing is fiscally sensitive. And you can't say it louder than the Constitution itself tells us, that it is realizable progressively. Keeley also dealt with this issue, and his evidence can be found against paragraph 1719, page 517, where he considered that the Fraser House development was related to the iChip program, and this was one step in achieving it. However, the city did not meet the overall target of TEAs in accordance with iChip. So we spin again to the same point, that until such time as you have a solution to what is a grotesque shortage of affordable social housing in the city, you get back to square one. We deal in our reply where we explain what we understand to be iChip. And as a broad statement, we say until such time as that affordable social housing in the city is addressed, all other measures are unable to provide the dignity that the people in bed buildings are entitled to. And we also say, on the facts as accepted, the Commission can at best recommend that the iChip model be revisited with a view to, in part, provide a solution for affordable social housing demand in the city. The city requires an iChip-like solution with the necessary adjustments that must be made to it, and maybe a useful point of reference going forward. We dealt with the question of the fire, and I don't think we can have any greater clarity than we did with the witness yesterday, who, as I read, his evidence is telling us that the peril at which the tenants in bed buildings are facing remains profound. And it is not one that can be ignored because it directs fatal consequences that succumb to those fires and scores of injury to the others. It might also be helpful to go to paragraph 1746, and we look at that on page 523 of the submissions, where Mukavele gives evidence in relation to EMS and the fire and the submissions we have made there. But as I say, we can also go to page 523, also where Mukabela proposed that all buildings comply with safety regulations. But that sounds to us as evidence leader more noise than realizable goals. To prevent fire hazards, abandoned hijacked buildings, and unsafe buildings should be addressed by the EMS. The law would tell us that. We also heard how at the center of focus in relation to the hazards that the fire presents is education. And nobody can quarrel with that as a proposition, that education. Well, the witness did not help much by saying in some of the buildings that they visited, they found Portuguese-speaking people there. So maybe there'll have to be an interpreter there to help with the education exercise, because the threat is regardless of statehood of individuals that get impacted by the risk and the hazard. And Mukavela also considered that EMS does not routinely inspect bad buildings, and that more TAs are needed to deal with them, especially where they are not compliant. But Chair, you'd recall the evidence in this regard. When we had the evidence of, I think it's General Inspector Jagla of the JMPD, they don't deploy inspectors on a particular given program. They meet every morning, decide what is to be done that morning, and if, for argument's sake, city power requires to go and do some disconnection, then they would do this 10+1 regime that would go to that building to help address security risks of the officials who are going to do the disconnection. But I can't repeat myself more to say that hardly is a solution. That very termination may be legally competent to do, just exacerbates the problem. We deal in our reply in paragraph 5 and 6, and that Chair you'll find on page 8 and 9. And I'm minded to say that reading what Seri ICF tells us is that, yes, there may be all of these problems, but in the interim, there must be provision of these services, electricity, water, sanitation in these bed buildings. But also there, that submission is not sensitive to the limitations that we addressed a little earlier about how access to those services can be obtained. So we deal with that there. But there can be opposition to a recommendation that potable water is possible interim solution to provide that type of service to the bed buildings. And as we make the point that perhaps some engineering solution is also possible, as the witness told us, some of this may be offered even through a battery-operated medium to provide at least lighting to escape routes in the event of the dreaded hazard happening. Now, dealing with TAs, again, the evidence is that they're insufficient to deal with the burden that these bed buildings must help address. They're just insufficient, and the city sitting even with evictions that may be legally competent and indicated by structural engineers who come to the conclusion that the structural integrity of a particular building poses a serious threat to those who occupy them. But there's no sufficient TAs. They too, you'd recall, Chair, according to the policy, were supposed to contain or provide emergency services for no longer than 6 months, but they have become a permanent home to those who live in them. So the demand for TAs can be more pressing, and the city should be told it's not an if. As the word implies, temporary emergency accommodation is because, one, it should be temporary, two, it's not a discretionary issue, it's an emergency, and it must be an accommodation. But you can't provide a TA when you don't have secure tenure as a follow-up step to that TA provision. And we repeat again the evidence of Mr. Mahlangu, who, Chair, you will find on page 490. Regretfully, even the audits that are required to be done in these TAs are not done with any consistency. And it's uncomfortable that some of the tenants in these TAs can afford to be in some of the accommodations that are offered by JOSCO. As an example, Mr. Mahlangu it's a stipend maybe, but it's a stipend of over 5,000 rand a month. Surely that accommodation he's occupying has people who deserve it more. But it don't happen if you are not getting regular audits. In that regard, we also had the witnesses of Katani, Motswani, Mboia, who dealt with the subject and had to admittedly concede and also illuminate the struggle that these tenements offer to those who occupy them. We also pointed to some of city-owned properties that are abandoned, but which can offer viable alternative TEAs if the energies of the city are properly directed. There we have in mind the Glenesk and Mayfair, portions of hectareage of available land space. So whereas the city may shout loud that they have no space in the city, it's not factually correct. The inspections have shown us that to be the position. We also had the evidence of the legal head Malahlela regarding demolition of buildings and what they try to do in that regard. He testified that there are challenges with eviction orders, mainly because of shortage of temporary emergency accommodations. But again, there is no point if government officials take and I don't mean any disrespect, but take a supine position in relation to something that's a threat to life and limb. They must find a solution, and that's why they are a government. Again, we point to page 523, where Mukavela accepts that there ought to be routine inspections to these bed buildings on a program that is measurable. In our reply, we say, or propose a recommendation that all the TEAs require a fresh and ongoing assessment, including audits of the people who live in them. The maintenance and upkeep of the TEAs is also supported. I have touched a little on what is not discernible yet, but a possible contribution to the solution by the President's working group. The evidence is that to the extent it was implemented in Durban, it is showing promise of being part of the solution, and would encourage the collaborative evidence we have had about when national, province, and city will meet to address and mitigate these challenges, including the bed building challenges. Bed building strategy appears to be a program that is but there administratively. It doesn't seem to have the sanction of council or the sanction of the mayoral committee. To the extent that it offers amelioration or mitigation of the problem, the Commission can support it. We deal with that in our reply against paragraph 2.10 on page 7. Again, I addressed what the witness Mboia would tell us about the engagement of committees that help within this bed buildings environment. JICA also told us about it, supports community policing and visibility because that's their legal mandate to start with. But again, we should be careful that it is not simply words, but there would be action in the observance of these bylaws and why there should be consequences to non-compliance. The problem, again, if I may just fleetingly touch on it, there are no consequences, Chair, to all of this decay in the city. In fact, regrettably, when we dealt in part one with city-owned properties, and we had the evidence of Ms. Bota, and you invited the board to look at their performance as a property-owning entity of the city. What happened, she now got promoted to a position of COO. That's painful. Well, we don't know the reasons for it, but and maybe we can't do more than just saying. The evidence also pointed to the limitations on having so many of executive positions being occupied on an acting basis. It is a limitation that must be resolved. And we should not forget the evidence of Rivers, who told us that private-public partnerships are in part a solution to the resolution of this right that is realizable progressively by the state. Remington House is being given as a solution, but as we make the point a little earlier, it too has problems. You'd see, Chair, in our written submissions, we also say there has to be a alternative dispute resolution platform created to address ongoing dislocation that happens between the residents and the city. I know we are told there is a municipal courts that are ostensibly presided over by magistrates, but the nature of the problem is that tenement of this kind is always urgent. And unless we have, even if in the immediate future, a solution that, as we know, alternative dispute resolution platform like mediation, conciliation, are in themselves not binding on those who participate in them. But at least they are a platform where two adversarial positions are held, and there is an intermediary who comes in to try and help them, one, identify the problem, and two, to the extent that they are in agreement, can resolve that problem. Well, again, a commission, Chair, unfortunately, is not competent, I don't think, to tell the executive or the legislature or the council how to do the budgetary priorities. A system like a democratic system, which our Constitution promises all of us, says those political questions lie with legal structures, and the mandates are defined in the statutes, policies, and implemented by the executive, and if not, judicially reviewed and corrected. We also dealt with the evidence of Mezondo, which in large measure echoed or was echoed by the various experts that SERI ICF led. And again, difficult to criticize their foundation, but impossible unless costed and funded. So our protest is limited to saying, whereas we are eloquent in the description of the problem, we are less so in the solutions that must be offered in resolution of those problems. I've also touched on the question of influx of internal immigrants into the city, as well as foreigners, and the challenges of overcrowding that brings. So it might continue to be a moving target unless a broad solution, such as the rate of unemployment in the country, is otherwise addressed. JOSCO does not have enough, does not collect enough. It's been now repurposed, we are told. They are told that they are no longer going to be having city bailouts. Well, that does not solve the problem. It magnifies the problem, regrettably.
What about JOSCO's financial situation?
It is getting worse, Chair, because in the first place, we now know that if they filled the positions that are vacant, that would cost 30% of their budget. So without being disrespectful, they must find a solution even with the budgetary constraints that they say exist. And it does not help that the city says, we're walking away from this problem because you're just not collecting enough. Firstly, that argument does not admit the constraints that reside with a structure like JOSCO, which is intended to be a solution of those who are in the lowest economic rung, and a class and a category of people who are already indigent and looking for solutions. Perhaps what the Commission can say is that that model must also be reconfigured, recalibrated, and see if there is a potential for a solution there. But it looks like an inoperable city structure that is sitting in JOSCO with nobody providing a solution in that regard. We can go even to look at that and the budget allocations that have been provided in the evidence of Clearly. That you will find on page 516 of the written submissions. We also deal with it in a reply. And as we make the observation, the tenants in the bed buildings live in despicable conditions of squalor. The living conditions are inhospitable and an apparent erosion of the dignity of those who inhabit them. But again, we go back. This decay is a function of shortage of affordable social housing that the city has an obligation in law to provide, albeit on a progressive basis. Chair, the Commission is invited to deal with the prevalence of bed building in Region F. And here we unfortunately having a non-resolutive evidence on what that prevalence looks like. According to Nkwani, the city has approximately 412 bed buildings. And if most of them look half of the disturbing images we saw in the 100-odd buildings that were inspected, that may represent 20% prevalence in the city. But by way of extrapolation, one expert, Rivers, told us that the prevalence of bed buildings in Region F is approximately 200, which by extrapolation may mean 10% in Region F. So as a direct answer to that question, which the terms of reference says the Commission must inquire into, that seems to be the continuum of the problem, approximately 10 to 20% of Region F. We also had Mr. Makola, acting city manager, tell us that he has initiated certain workshops that are seeking to look into this problem, but he can't with confidence say he's going to remain in that position. It's still on an acting basis, which touches again on the earlier submissions we have made, why running a government with acting appointments is unhelpful. Chair, maybe let us stop here.
Yes, before you stop, Mr. Siminya, having regard to our terms of reference, should buildings occupied as TEAs be considered to fall under our terms of reference?
Well, as the evidence tells us, Chair, the first place to start is to accept that the TAs, by design, are not our terms of reference. But you are not going to be able to resolve that problem if you don't have evacuation space, which the city policy says are TEAs, temporary emergency accommodation. But even that, if not properly dealt with, does not help resolve the bed building problem.
Yes.
And we are told that even overcapacitated, those TEAs. But our initial submission would be no, Chair. They are not squarely within the terms of reference. They are just a means by which those issues of bed buildings appears to alleviate to the extent that they do. But they're not a solution.
Yes.
Those would be our submissions, Chair. We will try and see what it is that further submissions are made and which would require a reply.
Thank you.
Thank you, Chair.
Mr. Sidumedi?
Good morning, Chair. Good morning, Commissioner Mabena. I can re-greet, Chair. Clearly, my initial greeting was not on record. So in some I'm saying my doing so I can greet the chairperson and
Yes.
Mabena again. Chair, in providing oral version of our submission, I think we are going to follow the topics as highlighted in our closing arguments. We'll put the closing arguments and the reply there too. Obviously, one is not going to go paragraph by paragraph,
Yes.
but just to highlight the key issues that arise from these written submissions. The overall theme of the submission is that the city accepts that things could have been done better. In actual fact, if we had performed as expected, even this commission would not have been set up. That is in a perfect world. But we also accept that there's an inherent risk in running a modern state machinery. Despite the good intentions that the state might have in adhering to its constitutional obligations, somewhere along the lines, things don't go according to plan. Be it financial and other socio-economic challenges. So that's a package that I think needs to be understood. It is not in any way meant to be a justification for the failures of the city, but just to acknowledge that running a state is not as simple and straightforward as one would have preferred to be. But despite all those issues, various witnesses of the city that came, especially for Part B, were able to demonstrate that this is a city at work. There are steps towards the
After the advent of the commission.
after
Seems to be
the
the city at work.
at least that shows as well the city is not oblivious to what happens around it. Where there are crises, they are able to recalibrate and refocus their energies. That's a fair point, Chair, that indeed most of the issues that happened were Usindiso was a wake-up call to the city. It would have been a travesty if, despite Usindiso, the city still went as if nothing has happened. So the fact that the commission was set up and Usindiso happened, and a commission was set up, the city had to rethink how it does its ways. It was not business as usual. So it is those parts that we thought we must emphasize, and the evidence that was led indicate exactly that issue, that there are immediate steps that were taken, and will demonstrate what are those immediate steps, what are the medium to long-term steps that the city, in the last year at least, have been able to sort out. And also touch on what the shortcomings are. Despite all those best intentions, what are the shortcomings that I think my colleagues from Siri blow out in their submissions? We will acknowledge what are those shortcomings and why, despite the best efforts, some of the interventions that you propose do not go far enough to meet the expectations of the poorest of the poor. I'll start first with the mandate, of this Part B of the Commission, which is the question that the Usindiso was touching on, the prevalence. Again, in an ideal state, the city should have been the first ones. The very first sitting ought to have came here and said, based on our good work, this is the prevalence of bad buildings. But because, like I've said, we are not in a perfect state, we are not able to give that answer outrightly. In actual fact, it had to take the commission to conduct an inspection in local. However, we cannot ignore the fact that even before this commission was set up, the city, through GFIS, were on an ongoing basis conducting inspections and collecting data of problematic buildings in the city. You'll recall even in Part A, Mr. Trevor Ramulumisi testified about inspections or investigations that they conduct throughout the city, and that evidence was zoomed in for Region F to determine if indeed buildings were hijacked or not hijacked. So that's the first source of data that at least the city put forth in an attempt to assist the commission to determine the prevalence of these buildings. Secondly, just want to refer to my notes. Secondly, obviously, it was the inspection in local. So the GFIS report, at least as at the time they testified, they had 104 buildings which are considered to be of a state that determine the prevalence of such buildings within the city. No, sorry, 164, my apologies, is 164, whereas the inspection in local yielded 104 buildings. For now, I'm not adding, I wasn't sure whether the new ones that were added by the evidence leaders in their replying, whether it's part of the 104, but for now, I'm using the 104 figure as an example. Of that 104, 6 of them were actually identified by GFIS already. So there's common cause of 6 buildings between the city and the commission. So already adding up on the list of the commission, already the city had brought other buildings to the table to demonstrate or to add, to assist in answering the prevalence of these bad buildings. Mr. Nkwani testified that as part of giving effect to the new way of doing things, they've also conducted audits in Region F. Yes, as the chairperson correctly pointed out, that was a response to what has happened last year. But at least with those efforts, now the city is in a position, or at least attempting, to get to grips of what is the prevalence of the bad buildings. So we submit that all these sources of information, GFIS, inspection reports, and the audits that were done by the city, they will help in terms of at least establishing a base from which the city could be able to determine the prevalence. Yes, we accept that, unfortunately, will be post the life of the commission, but I don't think we need to confine the state's interventions to time bound with the time of the commission. It would have been great if before the end of the commission, all that data was put to bear and we were able to answer the question conclusively. So as part of the recommendation would be, seeing that already work has been undertaken by the city to determine prevalence and even interventions on those buildings, the city must at least be advised, or a recommendation out of the commission that there must be ongoing audits so as to make a proper assessment, one, of the prevalence, and again, it doesn't help to say this is the prevalence. It must be what are the steps that the city is doing to ensure that the prevalence is reduced, or what are the steps that have been taken to make interventions to ensure that all these issues do not arise. So it is that should be what must come out of the commission insofar as that prevalence is concerned. We are not working from zero. There is a database that can be used to make that determination. Part 2, or section, the next segment of the heads deals with as well as to give effect to the state work, what are the remedies that we have since adopted post Usindiso and in response to the crisis that happened? One, Mr. Makola spoke about the building strategy. Yes, I know our colleagues would have preferred a full implementation of iChip. But Makola has told us that iChip in its current format was simply not achievable. He's not being any excuse that it's a bad document. We all
Simply not achievable, Mr. Sidumi.
at least within his current means currently. We cannot attain.
I thought his evidence was that iChip is being implemented side by side with the bad building strategy.
I'm just coming.
So what do you mean by saying it was not achievable?
No. You recall, Chair, that a question was posed to Mr. Makola. Why are you not implementing? iChip has everything. There's budget. Why are you not implementing as is? Why has the city not implemented its iChip as is? He told us that currently, one, unaffordable. It is a good document, which is why when he developed the building strategy, key elements were borrowed from iChip. So iChip has not been abandoned. It finds expression in the building strategy, but there was no point in saying we can implement as is with its budgetary requirement.
If it is not affordable, how come it is implemented side by side with the bad building strategy?
Chair, the evidence was that key elements were borrowed from iChip to see how the city can achieve some of its objectives. That's exactly the divergence between Siri and Mr. Makola. Siri was saying, implement iChip as is. This is why even in their recommendation, they are saying, let the commission direct the city to provide budget and implement iChip as is. Makola said, iChip, even though it wasn't adopted by council, it has not been abandoned. Instead, elements of iChip are being given effect to inform what they are doing. That's the evidence that Makola and other officials have spoken about. It hasn't been abandoned, but it has been accepted that over the years, it could not be implemented as is because of budgetary limitations. And as well, he even mentioned the fact that some of the assumptions made in iChip will have to be revisited and be modernized to the current state. So iChip as a concept has not been wholly abandoned, but it has been taken into account when the building strategy was implemented. You'll recall as well, Chair, when you took the evidence of the statement of Nkwani, in one of the paragraphs, he highlighted the 8 elements that were taken directly from iChip and how those elements are being implemented within the current building strategy. So that's where the issue is about. That's a relationship between the building strategy and iChip, Chair. It is not the fact that iChip has been abandoned, but instead, that which has been achievable has been transplanted into the building strategy. So I thought I must just clarify that issue about iChip, just in case maybe there's any misunderstanding, Chair, as to how iChip is currently, what is the status of iChip currently insofar as the city is concerned.
Yes.
Yes.
It is a worrying concern for me.
So is the chair still not, despite my efforts, is the chair still not clarified about?
Well, you may proceed.
Okay, thank you, Chair. So that's one part about the administration. Secondly, testimony was led that since Mr. Makola took over as the acting manager, I know the issue of acting is also a worrying aspect. I will address that aspect later on in my arguments. That instead of waiting for grand schemes and plans, he had to ensure that there are inspections that are taking place within Region F. He accepts that taking the problem of building strategy citywide with its limited resources, it won't be helpful. Instead, he advised us in his committee that he had to rechannel resources from other regions and concentrate on Region F amongst others, with the hope that after a month or two, they will move to other regions and thereafter come back again in Region F. So all that, again, Chair, is a demonstration that the city is at least doing something to get to the bottom of what is happening in Region F. Now, not only is there a question of just going there and identifying, where possible, make interventions. He told us about the intervention that they made in moth building. Of course, we know that there was a resistance to moth building, but the point is, side by side with inspections, as and when they identify problems, they try to intervene. The fact that there was resistance, that's another issue that he told us about, that look, obviously, they have to go back and see how best would the relocation of persons from bad buildings could be accepted by their host residents. Again, that is a societal issue that is there. It doesn't mean that the city is not doing anything. The city is attempting to resolve moth building because it has been identified as a bad building. In actual fact, he did testify that moth was just about one. There were around about 4 buildings that were identified for intervention. But they had to press a pause button because of the reaction that was prevalent in Soweto area when the people could not accept the residents of moth building. But the point being, at least those persons were relocated and the political intervention to see how to soften the ground in the host communities. Evidence was laid about 65 de Villiers. Yes, we accept that obviously the correct legal channels were not followed in shutting down 65 de Villiers. But the point that I want to take out of that was that when they are on the ground, the city was attempting to make interventions with the sole aim of addressing the crisis. There was no malice in terms of saying we're going to ignore the law, but it's just a demonstration of the agency to which the city sees the crisis in Region F. And obviously, with legal advice and going forward, they will find other ways of finding a solution to address the challenges in Region F. That's the second aspect. Thirdly, testimony was led about the partnerships that the city has forged with other stakeholders. In actual fact, the building strategy itself is a product of a workshop that was held with various stakeholders who are affected by what is happening in the city, and that's what led to the building strategy. So I won't go through each of the partnerships, but at least it was a demonstration that the city accepts that by itself, it won't be able to address these challenges. COGTA has to come to the party. Private sector has to come to the party. As to the extent and the pace to which that happens, that's another issue. But as a principle, it demonstrates that the city is actually accepting its limitations and roping in those that can assist. I won't go through the presidential working group because that's a fairly new concept. One still have to see what is the plan around that issue. But again, it shows that, or is actually an acknowledgement that the city by itself, it cannot resolve the issues in the university without the assistance of the other relevant role players. The fourth intervention remedy is the thorny one of the bylaw enforcement. We have put up in our heads that this is one issue that we accept was not done in a manner that would have assisted to resolve our challenges. That is the acknowledgement that the city has made. But Makola has told us that he has put up 22 million, because one of the challenges under bylaw enforcement was the issue of the vacancies. He has allocated 22 million only for JMPD. I'm not yet talking about the budget for the entire city to resolve the issue of vacancies. So as a priority, 22 million was made available to the JMPD for them to fill up vacancies. Chief of Police, Mr. Jagda, is evidence of that drive. Because for the longest of time, the city never had a permanent chief of police. And that was identified as one of the major contributing factors in a disjunctured manner in which bylaws were enforced. Jagda has now come on board and he has told us that he is moving away from the ordinary of how things have been done. He told us about a ward-based policing that they have adopted, which is an integrated approach in terms of how they enforce bylaws. However, there's one thing I think we need to talk about that I know might arise from Siri and other colleagues. JMPD in its current format, in as much as there are a plethora of bylaws that must be enforced, JMPD only enforces, or within their capacity, they're only able to inherently deal with what they termed non-technical bylaws, meaning we cannot expect the JMPD to be able to know if a building is not structurally sound. Instead, what happens there, that bylaw is a responsibility of an expert department, but then JMP then provides support. So I think that's one part that I think still needs to be made, because I think an impression was created that JMPD is not in any way enforcing bylaws. Yes, JMPD does enforce bylaws, but there are bylaws that fall within their domain, hawkers, traffic, and other crime-related bylaws, but those that require expertise of building planners and building controllers are the domain of certain user departments to which JMPD provides support, which is why when it speaks about ward-based policing, they are able to then know, because every morning there is a parade where different departments are able to request JMPD to assign relevant officials that can go and assist them in their inspection. So for now, we'll have to see as time goes on as to what are the results that we'll see that will come out of this ward-based policing, which Chief of Police Jaka have spoken about. Budget in the overall, next item, can never be enough. I don't think we'll ever get to a stage, and you say that in our submission, where we say budget can never be enough. It's an ongoing challenge, but within our means, we are, as a city, putting money aside to address some of the challenges. I've spoken about the 22 million for the JMPD, but Makola confirmed that as part of capacitation of the other departments and entities in the city, he has set up a total of 100 million to see how the vacancies within the city can be set aside. Mr. Nkwani did confirm that in actual fact, in as much as he's the acting head of Muslim, already there was a recruitment drive underway where he was trying to fill critical positions. Maybe that's what must talk about this issue of the acting. We accept that it is never the intention of the city to fill its vacancies, that's not even a feeling, to have critical departments being held by acting positions. Each and every case must be assessed on its own merit as to why. And I'll give you the example of Mr. Nkwani. Questions were put to Mr. Nkwani, say, Mr. Nkwani, you yourself, you are an acting head. How sure are we that all the things that you speak about here will be implemented? And the answer was, I don't know. I can't confirm for how long they'll be acting. But let's look at what led to Nkwani acting. I know this was not necessarily officially on record, but the reality of the matter is that the city actually had a recruitment process to fill up or to make that position to be a permanent position. But it was an interdict. Now, if there's an interdict against the filling up of the...
That's not the evidence before me, Mr.
I did consider, yes. I had said every issue must be dealt. So I was just giving that as an example.
In the light of the evidence before the commission.
I confirm that, Chair. We have never led evidence to explain that aspect. So that is the issue of the budgeting. The next part of our heads in paragraph, because I dealt with the remedies, the inspections, the bylaw enforcement, the progress on identification of TAs. Mr. Nkwani, and in our heads, this is why we did extract from the evidence of Mr. Nkwani, the projects that are in the pipeline for TAs. But again, some in the argument in the heads and testimony, we do accept that, and Mr. Advocate Simia has correctly had that aspect. Currently, the TAs are a bit of a misnomer because the word temporary seems not to be an operative word. Temporary is supposed to be an operative word, but from the look of things on the ground, they are more of a permanent feature. These are they are not necessarily temporary, despite the fact that the TA policy prescribes that there must be a tendency of 6 months, not longer than 6 months. But again, evidence was led as to what leads to that permanency creeping up. The idea is that people must go to a TA, they must then be assessed to see how can they be rechanneled. Those who qualify for RDPs should go that route, and those who are able to get other affordable housing should be channeled in that direction. But the reality is that what happens that when that happens, there are those who unfortunately not meet any of the requirements. Now, evicting them again is no solution because we are now back to the very same situation that led them to be evicted in the very first place. So it ends up being a vicious cycle where we are unable to evict persons out of the TEA to take them to another TA that where they will still not be able to qualify for whatever options, housing options that the state has. So that is a challenge that the city has, at pains, been trying to put at the commission. Obviously, that is not an excuse for not improving the situation, and evidence was led that there are other projects that have been identified. And these projects, as appears on page 13, 12, 13, and 14 of our heads, are a summary of those that have been identified as TAs. And you'll note from those projects that they are at various stages of completion, because on page 15, we provide a key. What is stage 1, what is stage 2, what is stage 3. But you'll note that at least this shows, I mean, there's 1 or 2 that are already on stage 1 to 4 that have been completed, which indicate that they are on the eve of execution. Yes, the majority of them are still at stage 1, that has been completed, being concept designs, where more detailed plans must still be undertaken. But again, these are not short-term arrangements. Provision of TAs is a long-term issue, and the city should not be criticized for the fact that currently there is nothing tangible in terms of budget for some of these projects. They are still in a planning phase, and there's a clear direction as to at what point would they be ready for implementation. So that share at a high level is just to indicate what is it that the city has been doing to ensure that the crisis in the inner city is getting attended to. Now, with all these good intentions, there has been limitations on what the city can be doing. So from paragraph 4 of our heads, we highlight some of these limitations. We accept, like Advocate Smith said, we don't take any issue with the obligations that we have as a city to provide water. I'll start first with water. There's a requirement by national policy that there needs to be free, certain number of kiloliters as a free water. But the current formulation is such that that can only be accessed by those who've got individual meters in their particular places of abode. The scheme does not envisage a situation where beneficiaries who are staying in blocks of flats or most of the buildings that are part of the Development Commission to be able to benefit. We are not saying those people must be shut down. We are simply saying, as a state, where we can, we are able to make provision to achieve the provision of free basic water. We accept, though, that tenants in these buildings are not able to do that, not because the city is refusing, purely because of the practicalities thereof. For as long as there's bulk metering in a building, and the relationship is between the owner of the building and the city, our hands are tied. Same principle applies to electricity. The only difference with the water is that at least Mr. Mukwevo did testify that in some of the instances, they were able to provide water tanks in the vicinity of such buildings. But again, there is no guarantee that the provision of that water tank will be consumed by those that qualify to access it. So those are the practicalities on the ground. It's not a refusal, but it's a reality that you are faced of saying, in as much as the state wishes to adhere to that which the policies require, there are chances on the ground that prohibits or inhibits the provision of such benefit. So water at least sits on a different pedestal. It gets a little bit worse when you speak about electricity, because that one again is a meter-based system where, again, the relationship between the customer, which is the owner of the building, and the city. Unlike water, where at least in some instances, Mr. Mukwebe tells us he was able to provide water tanks, we cannot provide an equivalent of water tanks to consumers of electricity for the 50 kilowatts as correctly espoused by Siri. Coupons or any other form, that can be done. The urgent issue is to say, as this commission, the city probably should find other ways of how it can ensure such benefit accrues, which is why when Makola spoke about the ESP, because this now lends us well into the concept of the expanded social programs that the city has. That in its current formulation, just like water and electricity, it is geared towards benefiting those who are able to have a direct relationship with the city. Mr. Makola was the first to admit that that model obviously excludes most of the occupants of the high-rise buildings in the inner city, which is why he had said there's already commissioned a study to say how best can we revise our policy to ensure.
Wasn't his evidence that it is under revision?
That's what I'm saying. Say yes, commissioned a study is under revision. When I said commission, I'm saying that that's a revision that I'm thinking about.
It is under revision.
I'm
The
saying,
revision has been implemented.
no, Chair. And that's what I'm saying. It's been reviewed, Chair.
Yes,
Yes. So I know a study has been commissioned to review the policy.
yes.
Yes, that's what I'm thinking about. I'm saying there's a process underway to revisit this policy to see to what extent can it address some of the shortcomings that has been highlighted by everybody, that in its current formulation is not able to benefit those that it was intended to benefit. So the fact that there is no benefit should not be seen as the city being anti-indigent. There are measures put in place to ensure that the indigent benefit, but we accept that despite the best efforts, such achievements cannot be adhered to. That was now dealing with the issue of it was paragraph 4. Paragraph 5. The bulk of our heads deal with the contents of the reports arising from the inspections in loco. Generally, we are at ad idem with the outcome of the reports. There is no basis of arguing that the buildings that are there are not in a state that they're supposed to be at. And that dire situation we accept, that had the city conducted its affairs in an ideal situation, it would have enforced the bylaws. So we accept as a general proposition that had you done things correctly, we ought to have ensured that our own bylaws are enforced. So to an extent that the reports recommend that the city administration, I'm assuming, must table a report to council where there must be a self-reporting of some sort to the political principal. I think that aspect, we take no issue with that. The city administration will, once the commission has at least finalized that aspect, provide a report to council to indicate which buildings. These ones and those other ones that might be coming out of our own chief's reports. However, there are points of divergence, not a lot, that I thought I must bring to the attention of the commission. The runabout, so I've put them up on my cell phone. In broad terms, there are around about 5 categories of recommendations that we thought we must just highlight, because that's where, if they are left as they are, it might be a little bit of a challenge for the city to give effect to. The first one is that it's on a theme of TAs, because there are around about 5 buildings where it is recommended that these buildings must be converted into TAs. First group is privately owned buildings. So there are privately owned buildings where it is recommended that they must be TAs. Now, the issue that we have is that if this is a privately owned building, it will not be possible for the city to simply convert that into a TA, because there is an owner in place. Up until we get our act together in terms of the expropriation of properties, and if a case can be made for that, that should something that must be. But as of now, it will be impossible for the cities to simply accept a recommendation that building X, which is in the hands of a private owner, ought to be converted into a TA. It is not within our means to do that because it is not our property. However, those buildings that are within the ownership of the city, and Patrick Semenya has indicated that there are a number of buildings that are city-owned, which could be converted into TAs. The point that we have made in our response that, look, obviously we'll look at what were the plans of the city initially for those types of for those specific buildings, and then where appropriate, then we will be able then to see if ever TAs could be. But it might be that as part of the master plan, some buildings were actually planned or earmarked for other plans of the city. So you can't just simply say because there is vacant, it must be made a TA. The city might be having other plans, but all those issues we are saying, city will make a determination to see what are the plans and what is the viability of the city converting that as part of TA, taking its cue or advice from the commission. But it can't just simply say automatically as a recommendation, building X must become a TA without first interrogating that aspect. The third category is one dealing with a problem, and as I say, in our table we have specified which buildings are you talking about, that the city ought to make use of its problem properties bylaw and appoint an administrator to take over. I'm just paraphrasing, take control of that building and continue, as was envisaged in the problem properties bylaw. We make a point in our response. As a principle, yes, evidence was there that these bylaws, that particular bylaw, in its current formulation, there has been some question marks raised about its constitutionality. So it might not be easy to just follow that. But we are saying, notwithstanding that challenge, the city will find other alternative mechanisms to ensure that the spirit of the recommendation is adhered to. So we are not simply saying as a city, no, we can't do it because the bylaws are still under review. We are simply saying the point is noted, but please note that currently the bylaws are under, there's question marks around it, but we will find other alternative mechanisms to ensure that the spirit is being adhered to. The last group, I think, is what the land use. A recommendation was that ensure that, I'm just paraphrasing again, Chair and Commissioner Mabena, that there must be compliance with the land use scheme of that particular property. We have said there, yes, we'll first have to make a determination as to whether, as a matter of fact, there are breaches or infractions of the use, the rights that are attached to that particular property. And of course, if indeed there is an infringement, we will take the remedial steps to ensure that such is complied with. So those are the 5 matters that I thought we must bring to the attention of the Commission, because I heard Mr. Advocate Simiya saying there's no issue with the reports. We agree insofar as they are state. We agree that indeed there's no dispute there, but we're just saying, please note those 5 deviations that we will not be comfortable if the recommendations as they stand will be adopted by the Chair and Commissioner Mabena. That is
Mr.
now,
Sidumedi,
Chair.
what should this commission find with regard to the issue of the problem property bylaws? I mean, the amount of time it has taken for this issue to be resolved is a cause for concern.
Point taken, Chair. The issue, I'm assuming the Chair is asking what recommendation should there be made by the Commission.
Yes.
Chair, I don't think anybody is going to quibble with any idea that suggests that there must be a time frame that the Commission can set up. So within this particular period, the city must ensure that whatever issues that it alleges are legal challenges in the implementation of the bylaw must be done. Whether we are talking, I don't want to stand here and proffer a time, but I think as a principle, time must be set out to say within this period, the city needs to review its bylaws
Yes.
and report to the Premier.
Because
Of course,
there is no evidence why it has taken this long.
I accept that, Chair, which is
You
why
accept that there is no evidence?
there is simply no evidence, Chair, that I can because I was privy to the paragraphs that spoke to the issue of the
Yes.
challenge. So I can confirm now, Chair, that there's not been any evidence. Neither was there any. Okay, I can't talk about what happened behind the scenes, but which is why, Chair, I'm comfortable to have a recommendation that sets out the time frame as to when must be done, and people must report to the Premier as by when, as to how far are they in implementing whatever revisions. Chair, I can quickly go through the issues. I've now touched on the key aspects on our main heads. There were a few items that I thought we must talk about that emanates from city submissions, and as part of our replying affidavit. Again, reply is on page. Broadly, there are 5 issues that Siri raises. It's policy issues, bureaucratic changes, non-compliance with court orders, the issues coming out of housing and the services. And I've put up the other miscellaneous aspect. On policy issues, it has been an ongoing cry from Siri that the concept of hijacked building is something that the Commission must recommend that it must cease to be used, as it has other effects, so they say. One is obviously alive and sensitive, and understand the sensitivities that Siri is raising about the effect that has, or the unintended effect of what a term has. But it is not born out of facts. the reality on the ground is that the majority of the buildings are occupied without the consent of the owner. And in most instances, or some instances, the owners, these occupiers, to their knowledge, they are paying some form of compensation to somebody who's not an owner.
In some instances.
Some instances. That's the way that I use Chair. Now, and MC Chaku did testify to this part, that every time, and this is what Chief is also confirmed to us in Part A, when you ask the occupants, in some instances, or most, they deny that they are paying rent because they know that then she's going to want to ask, who are you paying rental to? So the fact that
That's not the evidence before me.
he did, two witnesses Chair spoke about it. Trevor Ramolimisi and MMC Chwagu did testify that in one of his recent raids, that operation, that is always a tongue twister for me, they were able to interview residents who in private confided in them that indeed they are paying somebody, and those somebodies were traced back to Limpopo. That was the evidence of MMC Chwagu, Chairperson.
Yes, what I'm quibbling with is the reason why they were saying they are scared to disclose the identity of the person to whom rent was being paid.
Chair, I thought that was an obvious issue, that there must be a reason why. Otherwise, if we accept that they are paying, and people are not fully disclosing that they are paying this to Siamo Sidumedi, what would be the reason for that? Purely because of fear of victimization. I accept that there is no specific witness that has said that issue, but it can be reasonably inferred that this is done purely because of fear of victimization. That's the only reason why that could not be disclosed. And there's no witness, Chair, who would have the confidence of coming here and saying, I'm paying X amount to Mr. Sidumedi. Because Mr. Sidumedi will then ensure that that issue gets resolved in other ways which are not part of our legal system. So it makes sense why, despite talks on the ground, that evidence cannot be put to the commission. So based on that, Chair, we would want to submit that inasmuch as we note what Siri says, but the reality on the ground is that indeed people are occupying buildings without the consent of the owners and they're paying somebody. And that's where the issue of hijacking comes in. In actual fact, inasmuch as hijack was not used in PI actually criminalizes that conduct. That in the event that you occupy land without the consent of the owner and for remuneration, there is a criminal offense. That has been there already in our statutes. It's just that now it has been given a colloquial term called hijacking. We spoke about iChip. I know in that point there is saying that the commission must recommend that the city puts money aside for the full implementation of iChip. I've already spoken about that aspect in my earlier submissions, that Makola did indicate the difficulties in providing the budget for the full implementation of iChip as it stands, but he accepted that despite it not being adopted by a structure beyond mayoral committee, at an admin level, they have been borrowing elements of iChip.
Mr. Sidumedi, I get the impression that according to Mr. Makola, iChip did not require the consent of the mayoral council because it is a strategy in as much as the bed building strategy is.
Correct, Chair. And see, there's what Makola testified is correct, but we have put on the ground what happened on as a matter of fact. iChip document was root tabled with the ultimate intention of it going to council, but it only stopped halfway. Not because people were saying It's not necessary. There was an intention to take it to council. As to whether that was a correct route or not is another debate. But as a matter of fact,
Yes.
there was a routing of the document to go to council. Mr. Makola has correctly said, look, in any event, I don't see why my predecessors had to take this thing to council. Because in actual fact, even as much as a strategy document, I can actually borrow its elements and adapt it to a building strategy. So those
Yes.
are the factual positions that are there, Chair. We take no issue with there's a recommendation that the city must be directed to engage with National Housing Department about the emergency housing program. We take no issue about that issue. There's only one issue that came out of Advocate Seminar. I thought maybe if it is left unattended, it might just also have unintended consequences. The evidence about the emergency housing program is that is not like your normal fund that comes as part of your budgetary allocation that you must spend throughout your financial year. It's a specific program that you apply for in response to a specific crisis. It's not like the normal budget gets allocated to the city. You've got a crisis, like they spoke about, it was My project and the Rabi Ridge. You apply to national department for them to advance funds to that issue. There was no debate. The witness told us that these funds came 6 months after the fact, when you're already in the middle of the financial year. That's the reason why, I'm going to speak about the Arabic region in particular. That's the reason why the funds could not be the entire, in as much as they give us that which the state asked for. But giving the city that full amount halfway through the financial year is just not feasible and easy to implement. Because you need to quickly plan and spend the money before the financial year end. You submit plans to the treasury. This money came late. I could not spend your money for all these other reasons. Treasury, they've got their own process where they say, no, we don't accept your reasons. So why I'm raising this issue is to say an impression must not be created that the city continuously gets, in particular, emergency housing funds, which they are unable to spend. Every instance of an emergency housing that has not been spent must be viewed with specific reference to the peculiar circumstances of that particular program. It must not be confused like any other funding that comes at the beginning of the financial year. So that's a part that I just thought I must just put across. But of course, we do accept the recommendation to extent it is possible if the Commission has the authority to direct the national and province to come to the party on this issue. That's something I think one can always debate about the extent of the Commission's mandate, but I think that's in principle something that we are not averse to, because in actual fact, Mr. Ngwane did talk about the need for some of these programs to be revised. The next aspect is the issue of the bureaucratic changes. And I know as well spoke about, but the stronger sentiments coming from cities that the Commission must direct that the city must must appoint officials permanently. There is no intention by a city or any government to operate on acting positions. The intent is always to have permanent positions. I've explained that there might be circumstances, of course I do concede, Chair, that there were no specific evidences that was laid on each instance as to why this one is acting. In broad strokes, there's always been the issue of budget. So as a principle, we won't be averse to having permanent positions. But the appointment of permanent positions must take into account the availability of budget. Otherwise, you're going to end up having unfunded mandates. So to an extent, that the city is able to fill vacancies on the permanent basis, indeed, city must do so. And the city must report to the Premier why, in this particular instance, as a city, we are unable to fill up the position. So there must be ongoing monitoring of why certain posts could not be filled on a permanent basis. But just to make a permanent recommendation of that city, thou shalt have permanent appointments, we are going to have a situation where we lament the fact that the city has complied with the recommendations of the Commission, when in actual fact the issue was not about defiance, but structural challenges that are affecting why certain positions could not be urgently filled on a permanent basis. But it has been evidence of Makora. In any event, the intention is always to fill up all those vacancies. Which takes me to the next point about the non-compliance of court orders. City says the Commission must direct, or the impression that they want to paint is that a city is not a constitutional citizen. It is just has this propensity of not respecting court orders without putting context to issues. There is no court order that has been issued against the city where the city said, this one we are not going to comply with.
TAs, there were orders.
There were orders.
That evictions should be effected, and those were not complied with.
Correct, Chair. I said the operative weight is there was no order that the city, or has been made against the city, where the city has intentionally defied that order. In each instance. So the order will say, occupants of resident X are hereby, order A, where residents must be evacuated or evicted. Next paragraph, subject to the city providing alternative accommodation to the residents. Some of them, there's a sentence that says alternative accommodation must be agreed to with the occupants. Now, that's an order that gets dished out to the city. Now, if the city does not have alternative accommodation, or it has, but then the occupants are not agreeing to where they're supposed to be given to, technically the city is still in breach on the face of it. But the reality is that the city is unable to give effect to this order. So the issue of non-compliance is not a refusal, but instead inability to give effect to the orders, not because...
Do I have such evidence, Mr. Sidumedi?
Chair?
Do I have such evidence?
Chair, yes, there were... We gave example of 6 orders, Chair, that were issued, which had those conditions, Chair. And all the witnesses, Part A and Part B, had to...
In Part B, who in particular gave such evidence?
I know for a fact Mr. Nkwani, in his written submissions, spoke about the difficulties of why TA sometimes have a degree of permanence. I'm speaking under correction, I'll have to check the exact number, but I know in consultations, the head of legal, those are some of the things that would have came out of his written submissions. I was not here when it is, but I know that's one issue that has always been a constant headache on his side on why he has been unable to give effect to some of these court orders. I was speaking about the issue of the fourth element was housing-related issues in terms of the series submission, but I won't talk about that. But there's this aspect where social housing, in our heads, we address that part on page, paragraph 510 to 512. Broadly, the request from city is that the city must be directed, through Joshua in particular, to provide social housing to occupants who earn less than 3.5. I think that is and you recall, Chair, the context of 3.5 is that when Ms. Puleng Motebe testified, indicated that in terms of the band, the thresholds, 3.5 is their cutoff point. And the query is that, what about those who are below 3.5? And what is her explanation for why only 3.5? And even in that instance, 3.5 category was a bit of a smaller group compared to the higher income earning groups. Now, forcing Joshko to say, ensure that you provide more for social housing, two challenges with that proposition. It is attractive, but it ignores the fact that the model of the 3.5s and all that is something that has been prescribed by somebody else, being the Social Housing Regulatory Agency. So for Joshko to apply for funding for social housing, that is, they must follow the model as prescribed by SHRA. Failure to comply with SHRA's obligations, then you are in breach of your obligations to SHRA. That's the first part that Puleng talked about. Again, he then explained why that model. Because the reason why the 3.5 is a lower category, percentage-wise, compared to the other one, is that there must be cross-subsidizations in these units. So those who are earning a higher salaries or who are in a higher income brackets are actually cross-subsidizing the group that is earning 3.5, because you cannot run a social housing accommodation only on 3.5 earners. So that's the reason why the model looks like that. And I know the query was that seems as if preference is given to the higher earning groups as opposed to those who are below 3.5. But explanation was provided as to why that is the case. So we just then think it will be inappropriate for the Commission then to make a recommendation that says, Joshko for social housing must make provision for a bigger pool for the 1,500 earners without taking into account the financial model, and two, the fact that this is something that has been prescribed by SHRA. The last issue is a thorny issue of the committees, and I noted, Chair, in our written heads that an earlier version, which was a little bit robust or strong in tone, found its way in the submissions, but there's a softer tone that we have under paragraph, on our heads, it is paragraph 7.39 regarding the, and it's issues coming out of the experts, and I think it has been part of a discussion yesterday and even today about the engagement of the committees for whatever issues that pertain to the building. As a principle, the city is not averse to engaging any person, anybody who's able to assist in finding a resolution of whatever nature. The city's doors are open for engagement. All you're saying in the reverse paragraph is that we must caution or note that the occupants of the buildings, especially privately owned buildings, if you accept the principle of hijacked buildings, if you accept that as a proposition that they are hijacked buildings, some of the occupants who are partaking in that issue, they might as well be part of the committees. Now, in a privately owned building where the owner is at pains to get these occupants out of this building, and they've got a committee, now the city comes in there to engage that committee against the wishes of the owner. For whatever reasons, it puts the city in a bit of a challenge. Yesterday,
I thought these were abandoned buildings. So how can the owner be at pains to get them out?
Chair, the committees, it has not been evidence, at least to my understanding, I'm speaking under correction, that it is not each and every building that has been abandoned. There are buildings where the owner has lost control. He's trying to get occupants out, the occupants, they've got their own committee. So obviously where buildings are abandoned, that's something because there's nobody to engage with. That, Chair, is something that obviously one can speak to. But there are situations where there would be a structure of some sort that organizes those who are in occupation, but their occupation are not with the consent, or is not with the consent of the owner. Now, it puts the city in a very, very difficult position to say, we will ignore the wishes of the owner and deal directly with the owners or with the committee to see how we can reconnect, as an example, the services, right? I mean, yesterday, reference was made to Drislington inner house. Drisling industry house building. There's a judgment in 2022 where the city cut off power in that building because the owner had said, cut off, and they were represented by city, cut off this power because I'm tempting my agreement because my occupants, they don't want to leave. I want them to leave this building so that I can refurbish this building. Now, an interdict is brought to say, now, city, you cannot cut, reconnect. And Judge Marini was correct in saying, how can that be? There's no relationship between the city and its occupants. The relationship is between the city and its customer. The customer who had asked the city to terminate the agreement because he's unable to control what is happening in this building. Now, this same time, just as a scenario, there's a committee for now, because I'm not saying that's the case in that building. There's a committee in that building that is anti-owner, and they're saying city, reconnect. Now, the city comes in there and reconnect. What will be the legal basis? What does it tell a building owner? That the city can undermine my efforts to take control and deal directly with these residents. So those are simply saying we need to take caution when we look at the issue of engagement with the committees. That can be done. Committee members are residents of the city, but the city can also not be seen as promoting unlawfulness in some of the issues. But obviously, each case, again, like you said, Chair, must be assessed on its merit instead of just making a blanket recommendation that the city thou shall engage with established committees in buildings without understanding the context of that committee and its relationship to the owner of the building. Those, Chair, were the key issues that we thought we must raise coming out of serious issues. We didn't take much issue with the submissions from the Human Rights Commission because, by and large, they are reasserting the obligations that the city has towards attainment of the rights enshrined in our Constitution. So, like Advocate Smith said, anyone who wants to take you that, I think, then is not part of this country. So we are not taking any issue with that, and we're simply saying we do respect the law, but acknowledge that what are the issues that are forcing us not to ideally meet some of our constitutional obligations. Unless there are any issues that the Chair and Commissioner Mabena has, those will be our submissions, Chair.
Thank you, Mr. Sidimedi. What is your own view with regard to occupied building as TEAs? Should they fall under our purview in terms of our terms of reference?
No, Commissioner Chair, we have written a letter to the Commission, and I'm not trying to score brownie points here. We did last year in Part A, when you're preparing for Part B, to say if you look at the terms of reference, they are not saying go solve bad building problems in the inner city. They confined, the author of those TOR said, look at the prevalence of buildings that, one, are taken over by criminal syndicates. And I'm just paraphrasing, check, but there are two elements. It's taken over by criminal syndicates or other persons who are not the lawful owners of the buildings and are collecting rent from the occupants. Now, that should be the narrow focus of Part B. Of course, you accept that, you know, the other buildings end up, if you leave them, they will end up contributing. But as a matter of fact, currently, where a building has not been taken over by somebody who's not an owner, and there is no evidence of occupants paying some form of rental or compensation towards that owner, that, strictly speaking, should not form part of the mandate of the commission. In actual fact, even when we gave you data, we group them according to that. You said, in this group, we think these are, strictly speaking, falling within the confines of the commission, but to an extent that the commission is minded, for whatever reason, to consider other buildings as well that you think might, this separately. So that's the position of the city chairperson, to say it must only be confined to buildings that meet those two criteria.
Thank you.
Thank you, Chair.
Mr. Brickhill, I'm minded that we should adjourn for lunch and hear you after lunch. What is the time now?
12 minutes past 1.
12 minutes past 1. Is it convenient for us to be here at 2 o'clock, Mr. Brickhill?
Yes, Chairperson.
Yes.
Indeed, sir.
We'll reconvene at 2 o'clock. Mr. Brickhill?
Chairperson, Commissioner Mabena. At the outset, I did just want to record that the Inner City Federation were unable to be physically present here for closing argument because they're actually in urgent court at the moment before Judge Twala in the Johannesburg High Court in relation to one of the buildings that they assist. But I did want to place that on record. They are following the events online.
Okay.
Chairperson, it's appropriate for me also to begin, as my learned friend for the evidence leaders did, expressing gratitude to our colleagues, for the evidence leaders, for the city, for the Human Rights Commission, for the spirit and the collegiality with which they conducted the proceedings. Of course, there were disagreements along the way, but the process has been characterized by the sort of collegiality that one would like to expect in a matter of this nature. And our gratitude must also go, of course, to you, Chairperson, and Commissioner Mabena, for your role in guiding and leading the process. And to the staff who've run the Commission, the Secretariat, and all of the witnesses who availed their time. So we place our gratitude on record to everyone who's contributed to bringing the Commission now to this stage, the crucial closing stage. Chairperson, we have filed comprehensive heads of argument, covering, at least we sought to do so, all of the evidence that was led, the law and policies that apply, and proposing findings and recommendations, trying to be practical in doing so. And we included in Appendix A to our written submissions a set of proposed recommendations for the inspected buildings, going building by building, to be read alongside the evidence leaders' similar tabulation of the individual buildings. And then in Appendix B, Chairperson and Commissioner Mabena, we set out our proposed general recommendations in a form that looks something like akin to a draft order, but I must make some important comments at the outset because it's not a draft order. We accept, of course, that this Commission's role ultimately is to make findings and recommendations to the provincial executive. And those findings and recommendations are not binding. They don't have the status of a court order, but they play a crucial role of giving an expert input grounded in the evidence, the expert evidence, the individual evidence, and the argument and documents that the Commission has received. So although the Commission ultimately will issue recommendations, those recommendations would have a particularly persuasive force, we would expect, with the provincial government and with the city. Chairperson, if I may, we have made one amendment to our draft recommendations, and we have copies for the Commission and for all of the parties. I beg leave to hand it up. Perhaps my...
Thank you.
Chairperson, I'll return to the specific recommendations that we propose in due course, just to highlight that, and I do need a copy, please. The addition is paragraph 2, which is actually drawn from proposals or inputs from the evidence leaders, from the Human Rights Commission and the city. It's effectively about engagement with other parts of the government. And so we've added a proposed paragraph 2. But to be very clear, we accept that these would ultimately have the status of recommendations, and that is the Commission's appropriate role. The Commission does have scope, though, we would submit, to address matters of policy and matters of legal obligation, and to make recommendations on them. Unlike a court, the Commission is at large to make recommendations because it considers that they would be a good policy direction rooted in the Constitution for the city or other relevant role players. But I can return to that in due course. Chairperson, our heads of argument are carefully annotated and referenced to the evidence, to the transcript of the oral evidence, to the witness statements, and to the exhibits that were admitted. We have also previously provided a comprehensive law and policy bundle that includes what we submit are the key relevant policies and the most significant jurisprudence that bears on the issues that the Commission is required to consider. Again, I don't intend to traverse all of it in my oral submissions, but simply make the point that we have placed those resources at the Commission's disposal. We will not now cover our heads of argument in full or traverse them sequentially. We intend to focus on the issues in dispute and on our proposed findings and recommendations. And we agree with Mr. Semenya that the parties at this stage have coalesced around certain key areas of agreement which are fundamental to the Commission's terms of reference. This followed receiving the evidence of over 25 witnesses, substantial documentary exhibits, the inspections of over 100 buildings, all of which left the Commission, we submit, in a unique position. It is in a position, having done all of that enormous work, to reach a fuller understanding of the challenges of the inner city and potential solutions, of course, within the terms of reference. And after all of these processes, the main role players we submit have reached broad consensus on at least the following central issues. First, that there is a crisis of affordable housing in the inner city of Johannesburg. And my learned friend addressed it in his submissions earlier. The city too, and through all of its main witnesses, accepted that this is so. And it is so for a range of reasons. The social housing is effectively full. The TEA is also full. And there is no rental housing available on the market, whether provided by the state or by private actors, for the category of the community earning below around 3,500 or 3,200 Rand per month, that threshold. The second issue, Chairperson, which I'll frame as consensus, but I may need to qualify that in light of my learned friend Mr. Sidumedi's submissions earlier in oral argument. But it's around what the Commission should find about prevalence of buildings that have been quote-unquote hijacked versus being abandoned. And it was an issue that, Chairperson, you raised with Mr. Sidumedi earlier during his argument. It's our submission that the evidence before the Commission is very clear, that the vast majority of buildings that were inspected by the Commission or otherwise covered by the evidence were not hijacked as such, but were predominantly abandoned by their owners, whether by the city or by private owners. But given what Mr. Sidumedi said earlier, perhaps we can no longer say that that's common cause, but we submit that the evidence on that issue is clear. The third issue, Chairperson, that we submit is common cause, is that a large proportion of poor inner city residents currently lack access to basic services, including water, electricity, sanitation, and refuse removal. So it's common cause that a large proportion lack those services. And Chairperson, of the inspected buildings, we've done the calculation based on the tables provided and the findings of the evidence leaders, but it's above 50% and above 60% that lack water and electricity in those buildings. It's also common cause, Chairperson, that the lack of access to basic services aggravates, it worsens the conditions in the buildings and it aggravates the fire risk. That was broadly accepted, we submit, by all of the parties. And the fourth key fact, Chairperson, that we submit is common cause, is that there are real fire risks in a large proportion of the buildings. And Chairperson, it was perhaps appropriate to end the leading of witnesses yesterday with Mr. Gregg's evidence to recall that fire risk was the original reason that the Commission was established, that it's absolutely central to the terms of reference and role of the Commission. And what's common cause is that across a large proportion of the buildings, there are significant fire risks. They vary in their degree, but they're prevalent and common. So, Chairperson, those issues we submit are common cause. However, there does remain some disagreement, particularly resistance from the city on certain vital issues. And this arises in particular from their replying submissions. Our impression from the city's witnesses, in particular their key witnesses, was that there was significant consensus on these issues. But in their replying submissions, they appear to have backtracked on certain crucial issues. The first, Chairperson, is ICHIP and housing. And while the city, we understand, accepts its legal obligations to provide affordable housing, the status of its flagship policy, ICHIP, and what recommendations the Commission should make around ICHIP and housing delivery have been placed in some uncertainty by the city's replying submissions. That's the first issue. The second issue, Chairperson, is basic services and the ESP. And here the questions are whether it is competent, legally competent under the policy and otherwise to provide basic services, water and electricity in particular, to the buildings that the terms of reference covers. And the second part of that is whether it's practically possible. And this was the emphasis of our learned friends for the evidence leaders, the practical questions. So that's the second big issue, Chairperson, that we submit is still somewhat up in the air or where there is some disagreement. And the third, Chairperson, is around what we've called the broad policy approach and linking to the term hijacking. And the city has resisted our submissions on that front. So those seem to us to be three key issues that are still in dispute, in particular with the city: housing and ICHIP, second, basic services and the ESP, and third, the policy approach and the hijacking paradigm. Chairperson, I intend in due course to deal with the ICHIP and housing issue and the ESP issue in some detail, and to demonstrate to the Commission that in fact the evidence and the legal position are clear on those issues. Chairperson, as the Commission embarks on the task of preparing its report and adopting recommendations, we agree fully with the evidence leaders that those recommendations should be implementable. They should be realistic and achievable. And we are with them entirely on that aim, and it's with that in mind that we crafted what the proposed recommendations that we place before the Commission. Beyond being implementable, Chairperson and Commissioner, we argue that the recommendations and report of this Commission should make a positive difference in the lives of the people who live in the inner city, and not leave the city to repeat the same mistakes and keep doing things that have failed and failed and failed again. We are arguing for an approach that will revitalize the city's policies and implementation of them. It simply cannot be business as usual. If we continue doing the same things that have failed for 30 years, we can only expect the same results, which will be no change in the conditions, and in fact they're likely to worsen, and we'll have heightened risks, buildings that are in even more dangerous conditions for the people who live in them. And so, Chairperson, we do say that on these key issues of ICHIP and the ESP in particular, the city in its approach to argument in the replying submissions and what they've now placed before you is seeking, with respect, to lead the Commission to make what would be fundamental legal and factual errors. Errors we submit that would be so fundamental that they would potentially leave the Commission's final report vulnerable to review by a court. And we say so advisedly. And this, my learned friend, Mr. Semenya, made submissions on this prospect. It's one, no doubt, that all of us, having worked through the process for over a year and a half, would want absolutely to avoid. We would want the Commission's report to be implemented and to move forward and lead to positive change. Chairperson, there is one relevant legal authority not cited in our heads that we would mention here. We've cited it previously, I think, in our opening statement. But it's the decision of the Gauteng Local Division in Corruption Watch versus the Arms Procurement Commission, 2020, Volume 2, South African Law Reports, page 165, GP. And Chairperson, this was the review of the Arms Commission report, which, as the Commission will be aware, resulted in that report being reviewed and set aside by the High Court and leave to appeal ultimately failing. And importantly, the High Court, in a decision by Mlambo JP leading a full bench actually of other judges present, it was a special bench, held that the report of a Commission of Inquiry may be reviewable, but this is the important part. They ultimately set aside the Arms Commission report because of legal errors and ignoring documentary evidence, a path that Commission, the Arms Commission, had been led down by, in those proceedings, the evidence leaders and the representatives of the state, who appeared, in the court's view, calculated to cover up allegations of corruption and prevent them from being investigated. Now, Chairperson, this Commission has been a very different process with very different actors. But we submit that the Commission, in relation to those two issues of ICHIP and basic services of the ESP, is advancing positions that are so untenable, so glaringly wrong with respect, that they are exposing the Commission to the same risks of review. I will address both of those issues in some detail. They, to us, are the two priority issues that still arise for determination by this Commission. But Chairperson, I begin with the paradigm and this term of hijacking. It's a term that even finds itself in the terms of reference of the Commission. And Chairperson, the Commission has heard from SERI and the ICF, from experts, in particular Dr. Wilhelm Solomon, that the term hijacked buildings should be dropped from the city's lexicon, that it no longer has a place in our constitutional democracy. And Chairperson, when we've raised this issue through witnesses in cross-examination, it has been downplayed as an issue of semantics. It's just language, as a kind of quirk on our part. But we submit that it is absolutely fundamental. It is the starting point. It frames the whole paradigm, the way that we think about these issues. And it sets the paradigm for the Commission in approaching the issues under the terms of reference, including in particular the city and its obligations to the people who live in it. There is another paradigm, and it begins with the same letter, and it's the paradigm of a home. And Chairperson, this is not idealism, naivety, or semantics. A home, unlike a hijacked building, is a term that legal concept that actually is given meaning in our law. It is specifically provided for in Section 26(3) of the Constitution, in the right to housing. It is a concept that is dealt with and defined in the PI Act and in the jurisprudence of our courts, who have over time given meaning to what a home is. So we would put these two side by side. They're two different ways of seeing the city and the people in the inner city. The one framework is the hijacked buildings framework, that story of our inner city. The other is a framework, a paradigm of a home, of buildings in which ordinary people live, sustain livelihoods and build their lives, and hope to build better lives for their children and those who come after them. Unlike the term home, Chairperson, hijacked building has no legal meaning. And each of the city's witnesses, as we put it to them again and again, struggled to give it meaning. And they, in fact, gave it different meanings. We've heard fresh definitions again today from the city of what that term means. Sometimes it appears to mean unlawfully occupied, and that was the understanding advanced today in oral argument by Mr. Sidumedi, that it simply means unlawfully occupied. He then shifted, though, and I'll return to the later meaning that he advanced, but we also heard that it has connotations of unsafe or derelict. And in the city's replying submissions, there's a further new understanding of it linked to the crime of trespassing under our law. And in defending the use of the term, trespassing is now invoked. When we explored this line of reasoning with some of the witnesses, such as Mr. Makola and Mr. Nkwane, we eventually reached what seemed to be the nub of the meaning, which was unlawful rental collection. And Mr. Sidumedi did then turn to that conception in his oral submissions. That refers to the criminal offence created by Section 2.1 of the PI Act, which is collecting rental unlawfully. But Chairperson, this term remains, after all of those different meanings were advanced, entirely vague. That's the first difficulty with it. What does it even mean? It appears to be used often interchangeably with bad buildings. So policy documents or statements from the city will say bad and hijacked, or hijacked and bad, or hijacked and or bad. What that does, Chairperson, is it tends to pull all of those buildings into hijacked. So although there was acceptance that not all buildings are hijacked, and in fact, on the evidence that the Commission received, there were only allegations that 5 of the buildings involved unlawful rental collection out of over 100. That hijacked label tends to sweep everything under its cover. So it's vague, it has that sweeping character, and it also tends to connote criminality, which has been one of our main concerns with it, and something that Dr. Wilhelm Solomon addressed in his evidence. We are told in response, Chairperson, that, well, we certainly don't mean that everyone is a criminal. We only mean the hijackers. But that's not how it works in practice, with respect. And we can now see that, finally, emphatically, brutally, in the city's closing argument, in its replying submissions. Because at the end of this year and a half, Chairperson, and after what we had understood to be significant concessions by their key witnesses, their position boils down to this: they will not provide basic services to poor people living in the inner city in occupied buildings. They will not even talk to building committees and residents' associations in any of the inspected buildings. And Chairperson, I need here to refer to what the city says in its replying submissions. And my learned friend, with respect, sought to soften these paragraphs, or perhaps expressed some regret for having included them in their replying submissions in the first place. I won't speak for him. What their replying submissions say is the following, Chairperson. At page 16, paragraph 7.3.10, and this is after dealing with the definition of hijacking and under the heading now of engagement with committees. And there, the city's replying submissions say the following, I quote, "The implications of the city formally engaging with the committees that effectively hijacked these properties is that the city would be an accomplice to the crime of trespassing and others which are committed on a daily basis in these buildings." Chairperson, that is the submission that is made at the end of everything in reply to our submissions. Chairperson, the submission is not made in relation to some of the buildings. It's not some of the buildings, it's all of them. It's all of the committees in all of the buildings. It's not some of the people. The innocent residents are different from the hijackers. It's all of them. We won't engage with any of them. And Chairperson, this legal idea that this would somehow render the city an accomplice to the crime of trespassing is, with respect, ridiculous. It is one of the most untenable legal arguments that's been advanced in this commission since the beginning of the proceedings. As the Chairperson is well aware, we have a well-developed jurisprudence on meaningful engagement with occupiers, arising from the Olivia Road judgment and the line of cases that has followed. The very starting point, Chairperson, of that jurisprudence is that it is a duty of the city, or any municipality, to engage with unlawful occupiers. That's the starting point. They're unlawful occupiers under PI, and engagement is the duty, the remedy crafted by the Constitutional Court and developed by our later courts. So far from being a crime or rendering it some kind of an accomplice, it's actually the duty of the state, the duty of the city, to engage with residents and their representatives. It's also just good policy. It's a better approach. It produces better results. But I'll return to that in due course, Chairperson. I was dealing with this paradigm of hijacked buildings and what it leads to, because we can see it there very clearly in the city's replying submissions. The term hijacked buildings seeps into the thinking of our officials, our politicians, and their lawyers, and it leads them to think and approach every resident, every building, every time in the same way. They view the situation as one of criminality, not of need. They view the people living in those buildings as criminals, not as rights bearers. And they view the appropriate response as policing, enforcement, not as provision. They see the appropriate response as raids, and we heard again, disconnection of electricity and water as a means to deter people from living in the buildings, and the use of evictions. So, Chairperson, it's not just a term. The term provides the paradigm. And Chairperson, in this country, we are deeply alive to the harm, the hurt, the damage that words can do, and the way they drive our approach to governance, to the exercise of power. We know that from the racist epithets that were part of the law during apartheid, but also terms like illegal aliens and the harm that they can do and why we've departed from those in policy and in law. And hijacked buildings, Chairperson, we submit, falls in the same category. Where does it even come from, Chairperson, this term? It's not in the law. It's difficult to say. It seems to have seeped into the language of politicians and the language of property owners in the city in the early 90s during the transition. The Wikipedia entry on hijacked buildings in South Africa, because there is one, is instructive, and it reads as follows. Under the heading History of this term, hijacked buildings. The problem began during white flight at the end of apartheid in 1994, as big businesses moved out of the inner city into affluent suburbs, and the city experienced an influx of African migrants and South Africans seeking economic opportunities. This caused a housing crisis in South Africa's largest cities, Johannesburg and Durban. So, Chairperson, the term has its roots in the process of desegregating Johannesburg, with black residential communities moving into the inner city. We submit that the term has racist roots, and it is anti-poor. It's been adopted unthinkingly, and it just has a life of its own, continuing in the lexicon of politicians and officials, and indeed, crucially, in the language of property owners, private property owners. My learned friend for the city argues that, well, at the core, that term is about criminality. There is evidence of criminality. But, Chairperson, what are the facts? What is the evidence that this commission has received of this rampant criminality, which might justify, we can't quite conceive of this, but might lend support to an approach of thinking about the problem as one of primarily criminality of hijacking? Where is this evidence of rampant criminality. Only 5 of over 100 inspected buildings even saw allegations of illegal rent collection, so around 5%. After a year and a half, Chairperson, where is the city's evidence that this is a widespread process? My learned friend made the submission effectively that we simply know it happens and that the evidence isn't forthcoming because people don't want to reveal it. But we don't even have evidence of that. Where is the evidence of the GFIS inspections? We've heard about it vaguely and generally, but there's never been any substance to it, other than lists of buildings that are areas of concern for the city. It goes no higher than that, no further than that. And Chairperson, in relation to that actual offence, Section 2.1 of PI, where are the investigations and prosecutions? Dr. Wilhelm Solomon gave evidence on this based on his more than a decade of research, and he specifically investigated this issue. There have been very few investigations. The ICF gave evidence too that it has reported a couple of instances of illegal rental collection. There's been no effective investigation. So what we see is almost no investigations and even fewer prosecutions, at most 1 or 2 over a period of 15 to 20 years. So, Chairperson, we would submit that those facts show 2 things. First of all, that the scale of that problem of illegal rental collection is overstated, exaggerated. But secondly, that the response to it has, in any event, been ineffective because the response hasn't targeted that problem. Instead, Chairperson, this label of hijacked buildings is used to justify heavy-handed police raids that the Constitutional Court found in Industry House were actually designed to chase people away, and that was an ulterior purpose. And Chairperson, we would submit that beyond all of the evidence, the witnesses, what they may have said, their perspectives, with respect, the Commission saw for itself when it went into the communities, when it met residents and organizations like the ICF who organize in the inner city. Instead of gangsterism, you found grandmothers, caregivers, people building families and sustaining them. Instead of shootings, you found schools, like the school at Begezela Informal Settlement that the community had created for themselves. Instead of crime, you found communal living, people working together to clean and secure their homes. And instead of hostility, when we all came in, big delegation, including officials and JMPD, instead of hostility, Chairperson, you found requests for help and openness from residents and their leaders to bringing the commissioners into their homes, to sharing their problems and experiences, and asking for assistance from this commission in securing adequate housing and in securing basic services. So, Chairperson, it isn't merely semantics, this term of hijacked buildings, and we submit that it's time to mark a shift, a fundamental shift in our policy approach to the problems of the inner city by recommending that the city stop using the term hijacked buildings. And instead, Chairperson, adopt the legal paradigm rooted in our Constitution and in our law of a home, where we start by focusing on the people who live in the inner city rather than on buildings. Chairperson, that brings me then to deal with the terms of reference and a question that you posed to my colleagues earlier about TEAs and their place in the terms of reference. And we have 2 responses on that issue, Chairperson. The first is that we agree fully with the evidence leaders that, leaving aside for a moment the definition in the terms of reference, this commission cannot discharge its functions without investigating and making findings and appropriate recommendations on TEAs, because the problem is one that is inseparable from TEAs. And it would be artificial and irrational not to look at TEAs when they are part of this ecosystem, part of the city's proposed solutions in terms of moving people out of unsafe buildings and part of the legal framework. You simply can't look at those issues without considering the TEAs. So they're definitely part of the scope in that sense. But we would submit, Chairperson, that they are even more squarely within the scope for a second reason, which is that the evidence was clear that some of the TEAs have themselves been abandoned. When my learned friend, Mr. Sidumedi, addressed you on this earlier, he referred to the text in the terms of reference that refers to taken over by criminal syndicates. But he had no regard to the term abandoned. Abandoned buildings are expressly within the terms of reference of the Commission. In fact, over 90% of the buildings are abandoned rather than hijacked. And, Chairperson, several of the TEAs have been abandoned in that sense. The evidence leaders at that point in the proceedings placed on record that the Moth building had been abandoned. City-owned, it was occupied as a TEA, it had been abandoned. Several of the TEAs also lack basic services and present fire risks. So they meet the definitional requirements of the terms of reference too. So we would submit that they are squarely within the terms for that second reason too. They're not just incidental, part of the ecosystem, but actually they meet the definitional requirements. All but one of them, it's really only Fraser House, Chairperson, that was still in a fairly decent condition. Most of the others are dilapidated, poorly managed, if managed at all, little access control, lacking basic services. Many of them have been disconnected.
But Mr. Brickhill, are they poorly managed, very, very poorly managed, or abandoned?
Chairperson, they are almost all abandoned, and the degree of poor management is also variable. Fraser House is still relatively better off. The others,
it's the only one that we found to be in a better condition.
Chairperson, MBV1 is perhaps at the other end of the spectrum, where there's open sewage on the ground, open refuse that isn't collected, where electricity and water is not available freely. So they're really substantively indistinguishable from the other buildings, including buildings that are owned by the city. There can be no difference between a building owned by the city that it has abandoned, like Usindiso, and that is in poor condition, and another building that just happens to have been designated as TEA. It still falls within the terms of reference we would submit, Chairperson. So we say they're in for those two reasons, the reason given by the evidence leaders, but also because many of them are abandoned and meet the requirements. Chairperson, let me then turn to the two main issues that are in dispute. And those are the issues of housing delivery and ICHIP, and secondly, basic services and the ESP. And I'll begin with ICHIP and housing delivery. And Chairperson, in this regard, I want to begin first by drawing attention to some key legal authorities. We've provided really the full conspectus of important housing decisions in the case law bundle. There are only 3 decisions that I want to draw attention to and emphasize. One in particular, which is absolutely crucial, we would submit, which is the Commando decision. But the first 2 are Grootboom and Blue Moonlight. And on Grootboom, Chairperson, I'll be very brief. It's
Accessibility shortcuts.
Apologies, Chairperson. On Grootboom, I'll be brief. It's a decision with which people are very familiar. It's one of our landmark socioeconomic rights decisions. Its key principles include establishing that the housing right is justiciable, that it requires the state to take reasonable measures, that in doing so there are obligations on all 3 spheres of government, national, provincial, and local, and that those in the most desperate circumstances must be prioritized, and that the state ultimately must have a reasonable plan to discharge its obligations. Chairperson, we've made this submission previously that what Grootboom led to was the National Housing Code, and in particular the Emergency Housing Program. It was a direct response to the Grootboom decision. It was national government implementing the Grootboom decision. You can draw a straight line between Grootboom and the EHP. So Grootboom is fundamental and important on these issues. But Chairperson, we want to emphasize one paragraph of the Blue Moonlight decision, which is included in the case law, SERI case law bundle, and the relevant page is page 870, paragraph 74 of Blue Moonlight. And it's now dealing with the question of budget and resources, which has been one of the key areas of debate and concern around the city's obligations. And in paragraph 74, the Constitutional Court, per Justice van der Westhuizen, held that the city provided information relating specifically to its housing budget, but did not provide information relating to its budget situation in general. We do not know exactly what the city's overall financial position is. This court's determination of the reasonableness of measures within available resources cannot be restricted by budgetary and other decisions that may well have resulted from a mistaken understanding of constitutional or statutory obligations. In other words, it is not good enough for the city to state that it has not budgeted for something, if it should indeed have planned and budgeted for it in the fulfillment of its obligations. So, Chairperson, what we get from that is that there's a duty on the city in a setting like this one to provide the Commission with information about its budgetary position and what it can afford. We submit that very little has been provided on that score. It's very high level what was provided, and most of it actually was elicited from Mr. Makola in cross-examination. But, Chairperson, more fundamentally, the budget constraints are not some kind of absolute barrier to a court, or in this instance the Commission, considering whether the city has discharged its obligations or what those obligations are. It's not good enough, as the court said, for the city to state that it has not budgeted for something, if it should have done so in the fulfillment of its obligations. So, Chairperson, that we take from Blue Moonlight, but of even greater assistance we submit with respect is the Constitutional Court's very recent decision in Commando versus City of Cape Town, which was handed down late last year. And, Chairperson, this decision appears in the SERI case law bundle at page 1471. 1471. 1471. That's where the decision begins. Chairperson, this case concerned the City of Cape Town's emergency housing program and its provision of TEA, effectively. Was the City of Cape Town's policy of not providing any TEA in the inner city of Cape Town consistent with the Constitution? And ultimately, the entire Constitutional Court concluded it was not. It was unconstitutional for the City of Cape Town to say we will not provide TEA in the inner city. But the decision is particularly helpful because it engages the City of Cape Town's social housing policy and its emergency housing program. And it deals with both, and the questions of progressive realization and the obligations of a municipality. And we would submit that it applies with equal force to the City of Johannesburg. And, Chairperson, there are certain specific paragraphs to which we would want to draw your attention, and I'll do so. It's a decision, the majority decision is a judgment of Justice Matopo. Most of the court went with him. In fact, the only two judges who dissented, Bilchitz and Dodson, would actually have gone further and imposed a structural interdict on the City of Cape Town. So it was not that they wanted to do less. The court was unanimous on the core obligations. Chairperson, we would first refer the Commission to paragraph 69 of Justice Matopo's judgment, where the court explains these two programs, just like the City of Johannesburg, the social housing program and the emergency housing program. And the court distinguishes between the two programs, acknowledging that both at a national level are included in the National Housing Code, and effectively emphasizes that both are important. The City of Cape Town, any municipality, needs to do both, provide permanent affordable housing as well as temporary housing for people who face homelessness as a result of eviction. So both sets of obligations have to be met. That's paragraph 69. Chairperson, paragraph 71 of the judgment really summarizes the state of play in our housing jurisprudence under the heading, the defining features of the right to have access to adequate housing. And there, Justice Matopo, in sub-paragraphs that go from A to Q, summarize the jurisprudence, where it's led us. And it's for this reason, Chairperson, that we would submit that the Commando decision is the most appropriate starting point for this Commission with respect in understanding the city's constitutional obligations. Because Justice Matopo effectively tells the story of the development of our law from Grootboom through Blue Moonlight, Olivia Road onwards. And there are certain key features which we would emphasize from that summary in paragraph 71. And they're really paragraphs A to J of paragraph 71. The first, Chairperson, is that section 26.2, and I'm reading, section 26.2 of the Constitution requires a comprehensive and workable national housing program for which each sphere of government must accept responsibility. It also provides access to adequate housing for people at all economic levels of society. And then in B, measures aimed at giving effect to the right must be reasonable, both in conception and implementation. So the programs and policies must be reasonable on paper and in their implementation. And the court continues, they must be balanced and flexible. They must make adequate provision for attention to housing crisis and to, similar language to my learned friend, short, medium, and long-term needs, and must be continually reviewed. So that is the constitutional obligation. The policies must be balanced and flexible, make appropriate provision both for housing crises and to short, medium, and long-term needs, and they must be continually reviewed. In C, Chairperson, the principle of progressive realization is addressed. The right of access to adequate housing, the court holds, must be realized progressively, by which is meant that the right cannot be realized immediately, but, and we emphasize this, the state must take steps to make housing more accessible to a larger number and wider range of people as time progresses. So the fact that the right can't be realized immediately doesn't absolve the state of responsibility. The obligation is to expand access over time, in numbers. More people must get access to housing as time progresses. In paragraph D, Chairperson, Justice Matopo deals with available resources. And he holds, the state's obligation does not require it to do more than its available resources permit. This means that both the content of the obligation, in relation to the rate at which it is received, as well as the reasonableness of the measures employed to achieve the result, are governed by the availability of resources. Justice Matopo continues in E, the measures must be calculated to attain the goal expeditiously and effectively, but the availability of resources is an important factor in determining what is reasonable. In paragraph F, Justice Matopo makes the point that the context will vary from province to province, from city to city, from rural to urban areas, and from person to person. We would then highlight paragraph F, Chairperson, of paragraph 71. There, Justice Matopo holds that the ultimate goal is access by all people to permanent residential structures with secure tenure and convenient access to economic opportunities and health, educational, and social amenities. But because this will take time, provision must also be made for those in desperate need. So the ultimate goal is that everyone should have access to proper permanent residential housing. But in the meantime, there must be provision for those in desperate need. In paragraph I, Justice Matopo captures the now very well-established principle that in any eviction that may render persons homeless, meaningful engagement is constitutionally mandated, And in J, that alternative accommodation is required to be provided if there's a risk of homelessness. So, Chairperson, that set of sub-paragraphs we submit really captures the state of our housing jurisprudence. And in the footnotes, Justice Matopo, for the majority, has footnoted the earlier decisions. So it's really distilling and crystallizing our jurisprudence in those tight sub-paragraphs. Chairperson, we would then refer this commission with respect to paragraph 72. Paragraph 72, in the final sentence, Chairperson, provides that it is the constitutional duty of the state to arrange its resources in such a way that it is It is the constitutional duty of the state to arrange its resources in such a way that it is able to realize progressively all of the rights that are subject to progressive realization, including housing rights. In other words, the state must arrange its own resources in order to achieve the realization of the right to housing. And that's really the blue moonlight point, put a little bit differently, that the state has to budget to meet its obligations. It has to approach the budgeting process with its constitutional obligations at the front of its mind as it allocates resources, as it determines different weightings of priorities. Paragraph 73, Chairperson, speaks to the requirements for a housing policy and what will render it reasonable. There, Justice Matopo holds a housing program must be balanced, consider all sections of society, be flexible, and be able to reasonably respond progressively to housing crises and short, medium, and long-term needs. To be reasonable, crucially, Chairperson, Justice Matopo holds, to be reasonable, there must be sufficient weight towards the most needy and vulnerable, so that they can live in conditions of dignity, equality, and freedom guaranteed by the Bill of Rights. The state will be failing in its constitutional duties unless it takes reasonable steps towards addressing the needs of the most vulnerable groups. And we would submit, Chairperson, that the most vulnerable groups clearly include the residents of the buildings falling within this Commission's terms of reference. Chairperson, paragraph 76 is the next paragraph to which we would refer the Commission. There the court cites Olivia Road and makes the point that in Olivia Road the court held that the city of Johannesburg in that case must have foreseen the risk of homelessness. It must have had foresight of the risk that people faced and ought to have responded to that. Chairperson, if I can then take the Commission to paragraph 78, and that is under the heading Progressive Realization of Housing Rights. And there, the Constitutional Court, through Justice Matopo, refers to Section 26(2) of the Constitution, which incorporates the phrase progressive realization, and quotes the decision in Grootboom at paragraph 45, where Justice Yaqub held as follows, and this effectively remains the authoritative interpretation of progressive realization. The term progressive realization shows that it was contemplated that the right could not be realized immediately, but the goal of the Constitution is that the basic needs of all in our society be effectively met, and the requirement of progressive realization means that the state must take steps to achieve this goal. It means that accessibility should be progressively facilitated. Legal, administrative, operational, and financial hurdles should be examined and, where possible, lowered over time. And Chairperson, I won't read it, but paragraph 80 further elucidates the conception of progressive realization. In fact, there is one aspect that I would refer the Commission to. In paragraph 80, in fact, paragraph 80 as a whole is significant. Justice Matopo holds as follows. While this inquiry requires the availability of the state's limited resources to be at the forefront in determining the reasonableness of the measures employed to achieve the progressive realization of the right afforded by Section 26, we emphasize the following part. This cannot and should not be viewed as a free pass for the state to arbitrarily adopt specific or selective measures in the realization of this right through the prioritization of one constitutional obligation at the expense of another. Ideally, this balancing exercise would also entail a balancing of the emergency housing crisis with that of social housing development. So to pass constitutional muster, there has to be a balancing of emergency needs and permanent social housing development. And then in paragraph 81, the court continues. The court refers to the city's medium and long-term objectives, but then Justice Matopo holds crucially as follows regarding the City of Cape Town's approach. However, this broader vision appears to be a thoroughly misguided and ill-conceived project rooted in the perpetuation of spatial segregation and the infamous influx control in an attempt to inexplicably, quote, preserve the inner city by marginalizing poor persons. So, Chairperson, there the Constitutional Court was concerned with the City of Cape Town's policy of not providing TEA in the inner city, only doing so on the outskirts. But, Chairperson, we submit that similar concerns arise in Johannesburg around aims to preserve the inner city, marginalize poor people, and exclude them from it. And there's a tension there, Chairperson, between the hijacked buildings paradigm and the paradigm that recognizes that the inner city is home to significant communities who sustain livelihoods there. Chairperson, in paragraph 83, the Constitutional Court now turns to the City of Cape Town's emergency housing policy and finds that the failure of the city to allocate adequate resources to it, to emergency housing, undermines and infringes the right of access to housing for these vulnerable communities. It perpetuates inequality and violates its duty to protect the most vulnerable members of society. In paragraph 84, Chairperson, Justice Matopo acknowledges that the city operates within finite resources and must make difficult decisions about how to allocate those resources most effectively to meet the needs of its diverse population. However, the court holds, a lack of resources cannot be accepted as an excuse in the present circumstances, because that is simply not the reasoning behind its failure to prioritize emergency housing. The availability of resources is evident. And ultimately, in that paragraph, the court finds that the City of Cape Town has failed to progressively realize its constitutional obligation as far as emergency housing there is concerned. Chairperson, there are two final paragraphs that we will emphasize. The one is paragraph 88, under the heading, whether the city's conduct is reasonable. And again, Chairperson, the Constitutional Court has very helpfully in paragraph 88 distilled the principles that govern the reasonableness test with the development of our law as it currently stands. And there, Chairperson, the court holds reasonableness is the established test to assess progressive realization, refers to Grootboom, and then says the case established, the case being Grootboom, established the test for assessing the reasonableness of a government program, which must, and there are 6 subparagraphs. The program must, A, be comprehensive and coherent, B, be adopted by way of policy and legislative measures, C, be reasonably implemented, D, be flexible and balanced, E, not exclude a significant section of the population, and F, contain efficient assignment functions for all 3 spheres of government, and also be attentive to urgent needs. So those principles, again, helpfully distill the reasonableness test in the same way as progressive realization was earlier distilled by the court in commando. And Chairperson, the one final part of commando that we would emphasize is paragraph 89, the first sentence there, where Justice Matopo held the lack of an official temporary emergency accommodation policy indicates that the city has failed on that leg of the test. It firstly has a duty to have a policy in place. So from paragraph 89, we get the key principle that first of all, there must be a policy. There can't simply be a vacuum. The city just ad hoc acting, implementing administrative measures. There must be a housing policy which must meet those reasonableness principles. An obvious point, but a crucial one of relevance as we now turn to deal with ICHIP. And Chairperson, we would submit that of all the authorities, Commando is particularly significant. So what is the state of the evidence and argument at this stage on ICHIP? The city, in its written argument, and in particular its replying submissions, has now placed in question the status of ICHIP. In relation to the evidence leaders and also the city chairperson, questions have been raised around affordability of ICHIP and what that means for the Commission's role. We submit, Chairperson, that in this regard, the key evidence was that of Mr. Makola. In relation to what ICHIP is, how it was developed, how it was envisaged to be implemented, the key evidence was Dr. Zak. But in terms of its status, Mr. Makola, as the acting city manager, was most helpful. Because, Chairperson, you will recall Dr. Zak's evidence that she could confirm that the ICHIP had been adopted by the mayoral committee in 2017, but had not gone to council. She was unclear about its status. She spoke to it having been implemented in part, some 4 of its programs, to her knowledge, having been implemented in part, but she couldn't speak to its status within the city because she herself was outside the city. So this issue was raised very squarely with Mr. Makola. And Chairperson, we deal with this in our heads of argument from page 51, if I may take the Commission there. And Chairperson, we here deal with both questions, the status of ICHIP and its affordability.
What paragraph?
From paragraph 124, Chairperson. And the relevant references to Mr. Makola's evidence in the transcript are provided in the footnotes, Chairperson, so I shan't give those again. But just to highlight the key features of Mr. Makola's evidence. The first, Chairperson, was that ICHIP was approved by the mayoral committee in 2017, but not ultimately tabled before the municipal council. That fact was common cause. Dr. Zak knew that too. There's been no doubt about that question. Question was about its status. And here, Chairperson, Mr. Makola could not have been clearer. He testified that municipal council emphatically was not necessary because ICHIP is a strategy or a plan that does not require council approval and that it would only possibly have been placed before council to be noted. Chairperson, you raised this earlier with Mr. Sidumedi, and he indicated that, well, what we know is that there was a plan to place it before council. Well, Mr. Makola was clear that if it was to be placed before council, it would only have been to note ICHIP. It did not require council approval in order to be implemented. And Chairperson, as SERI and the ICF, we had been uncertain about its status before Mr. Makola testified. He made the position clear, and with respect, there could not be a better witness on that question than the acting city manager. someone who sits on the relevant structures and who is at a point in the hierarchy of the city that is particularly authoritative on its processes. There could not be a better witness on this question. But Chairperson, if there was any doubt about whether ICHIP had been adopted and then implemented, albeit partially, there are further facts that make that even clearer. And Chairperson, the first is that the new bad building strategy, developed only last year, confirms expressly that the city is implementing ICHIP. That is the language of the bad building strategy. And that the two instruments are meant to complement each other. So, Chairperson, my learned friend, Mr. Sidumedi, paraphrased this earlier, and his language was to the effect that some elements of ICHIP were being deployed. But Chairperson, Mr. Makola's evidence was stronger than that and clearer than that. ICHIP was being implemented, not in full, and its targets were not achieved, but it was being implemented. No ambiguity about that. And that the two instruments, the bad building strategy and ICHIP, were meant to complement each other, with ICHIP providing the bulk of the research to inform the city's current approach. And Chairperson, the bad building strategy also expressly commits to reviewing ICHIP, which was also Mr. Makola's evidence and the evidence of Mr. Nkwane. So that's the second fact. We have the bad building strategy and what it says about ICHIP, but there's further the evidence that the city has committed to reviewing, effectively updating ICHIP. And the evidence referred to a 5-year review. In relation to the level of implementation, we quote Mr. Makola in paragraph 126, where he testified that what ICHIP was essentially talking about was providing social or affordable housing within the inner city, which is Region F, which we completely agree with. Because in order to resolve the issue of bad buildings, but in the main to ensure that people settle in proper formal areas, we do need to provide that. So, Chairperson, what that evidence confirms is that substantively, ICHIP remains city policy. This isn't some external civil society imposition from the outside. It's not a clever idea of academics. It's the city's own program, developed by a team appointed by it, and Dr. Zach spoke to that process and the heavy involvement of city officials at every step along the way, including every presentation, the costing, and so on. But Mr. Makola confirms that that is the city's set of policy objectives, to provide affordable housing. So this isn't one of those matters, Chairperson, which we sometimes get in socioeconomic rights cases in courts, where there's a tension between the state's policy and what it wants to do, what it seeks to do, and what applicants who are challenging it contend should be its approach, such as in Treatment Action Campaign, where there was a direct clash in relation to the provision of antiretrovirals. In this matter, it is actually the city's policy to provide affordable housing as encapsulated in ICHIP. So, Chairperson, if we sum up Mr. Makola's evidence, it is that ICHIP, and we conclude this in paragraph 127, ICHIP was adopted by the city. It is being implemented today, as we sit here today. And importantly, it remains necessary. That was also the point that he was making in the part that we quoted. It's necessary to provide affordable housing in order to address the problem of so-called bad buildings in the inner city. And Chairperson, there seems to be common cause again on that issue. That was the starting point of my learned friend, Mr. Semenya, that it's necessary to provide affordable housing at scale to address the problem of unsafe buildings. Chairperson, in paragraph 128, Mr. Makola confirms the evidence of Dr. Zach regarding the involvement of city officials, that they were heavily involved in the original development of ICHIP, including the costing of its programs. And he accepted in his testimony under cross-examination that he still considers ICHIP to be viable and appropriate, that's what was put to him, as a general program of action. That was Mr. Makola's evidence. And Chairperson, that brings us then to questions of affordability, where there has been some debate, and my learned friends for the evidence leaders addressed the issue earlier. And Chairperson, it's first necessary to clarify, we deal with it elsewhere in our heads, but it's necessary first to clarify the costing. In fact, we do deal with it again in paragraph 129. It's this figure of 2 billion. What was the costing of ICHIP? And it's important to be clear on what its costing was, Chairperson, as developed and adopted in 2017 and intended to run for a 5-year period. Chairperson, first of all, during part of Mr. Makola's cross-examination by the evidence leaders, there was a figure of 2.9 billion was put to him. That was not the correct figure. The correct figure for the total costing was what my learned friend referred to earlier of around 2 billion. That was the total costing for 5 years. But there's an important further crucial qualification there, Chairperson, which we deal with in paragraph 129. Not all of that 2 billion was to come from the city's budget as ICHIP was developed. Only 1.3 billion of the costing was to be drawn from the city's budget. The remainder, effectively 700 million, was to be drawn from a combination of private funding, private debt and other secured private funding, and national government in the way that ICHIP was developed and costed. And Chairperson, there has been no suggestion that that approach was flawed in any way, that it was unrealistic at that time, especially bearing in mind that city officials were involved in the costing. It was not some pie in the sky. City officials sat in the room, engaged, bearing in mind the city's annual budget at that time. And Chairperson, in the remainder of this section of our heads, from paragraph 129 to 131, we deal with Mr. Makola's evidence on the affordability today, because my learned friend, Mr. Semenya, raised with him a concern about affordability in cross-examination. And Mr. Makola returned to this later. And we quote from him at some length in paragraph 129. We emphasize the underlined portion, Chairperson, on page 53 of the heads. Because effectively what I had put to Mr. Makola was whether he was contradicting himself. Because he had first said that ICHIP was viable, that it could be adopted as a starting point and it should simply be reviewed and recosted. And then he seemed to say, but it's unaffordable today. So we gave him the opportunity to clarify. And he gave quite a lengthy answer, which we quote. The underlined portion, Chairperson, reads, and I recall indicating that the current position that the city finds itself in financially may have an impact on that amount, referring to the 1.3 billion that the city would have to pay. But we would have to review that, and I think we both agreed that we may have to review that. And you even indicated that the strategy is reviewable every 5 years and would have to, that includes the financial viability of that. And in the next paragraph, he continues to say, well, this total amount, he's using the wrong figure of 2.9 billion, but it is expensive in the context of the city's overall budget. And we would have to, effectively, we would have to look at it, and we may need the private sector to come in, which in any event was already envisaged. It's part of ICHIP, that private sector involvement. So, Chairperson, we would sum up Mr. Makola's evidence in this regard as being, first of all, that ICHIP was adopted, didn't require council approval. It was being implemented in part by the city, not in full, and that in terms of its affordability, its original costings would be a useful starting point, but would need to be reviewed. What this commission does not have before it, Chairperson, is any evidence anywhere to suggest that the ICHIP costing is today completely unrealistic, should not be used as a starting point. Recall, Chairperson, that the overall budget of the city is approximately 80 billion. So the 1.3 billion over 5 years is less than 1% of that budget. So although it sounds to all of us laypersons, and it is a significant sum, it's a sum that is commensurate with the city's constitutional obligations and priorities. It was originally developed by the city and costed by it, and it remains the appropriate starting point. No doubt it would need to increase if the same provision were to be achieved today. That would cost more today than it would have in 2017. But we would be in the same approximate starting point, and the detailed work that went into ICHIP would enable that review process today to take place. And it's that, Chairperson, that we submit is the appropriate recommendation. And I'll return to the specific framing of it. But ultimately it is that ICHIP be reviewed, which the city has already said it has decided to do and intends to do, and implemented moving forward. And Chairperson, that would include assessing its affordability and the available resources of the city. So no one is suggesting any recommendation that requires the city to do more than its available resources allow it to do. Those are part of the inquiry, part of the city's process of reviewing ICHIP and updating it. Chairperson, in relation to ICHIP, then I would conclude with a couple of brief submissions in relation to the bad buildings strategy. And we deal with it in more detail in our heads of argument. My learned friend suggested that there's been no critique of the bad buildings strategy, that it's broadly accepted as legitimate. And that is so up to a point, Chairperson, but we do have significant criticisms of the policy, or at least a submission that needs to put it in its proper context. Chairperson, you'll recall that the bad buildings strategy was effectively developed over the last year. There is a question whether that process was prompted by the launch of this commission. That was never entirely clear, although there's certainly questions about that. But we would point to some significant limitations in that strategy, Chairperson. The first is just thinking about it in relation to ICHIP. Mr. Makola, and perhaps understandably because he had led the development of the bad buildings strategy, suggested, as we understood it, that the bad buildings strategy is now the big picture umbrella plan of the city, and that ICHIP falls under it somehow. Chairperson, we submit that that simply can't be so. Just looking at the two policies alongside each other, the bad buildings strategy is a narrow policy strategy directed only at 74 buildings, with 4 priority buildings. It's a plan to deal with certain specific buildings that have been identified. So put that on one side. A narrow plan to deal with certain specific buildings. Compare that to ICHIP, which looked at the entire need of the inner city and sought to develop a comprehensive program of action, combining state provision and private provision, a mix of subsidized private and state rentals, TEA, which is what bad building strategy mainly deals with, under 6 broad programs, as well as the facilitative support programs. ICHIP is broad, comprehensive. It's a wall-to-wall strategy that covers all aspects of temporary emergency housing and permanent social and other affordable housing in the inner city. It determined the need of around 30,000 households. It came up with a plan to provide for 9,500 units over 5 years at a cost of 2 billion, with 1.3 billion coming from the city and 700 million from national and private sources. So ICHIP was broad in its framing, whereas the bad buildings strategy only deals with one small piece. Those 74 so-called bad buildings that were either unsafe or where there was some allegation of illegal rent collection or some combination of the two. So that's our first main submission, Chairperson, that clearly the framing umbrella policy under which the city needs to be moving forward to deal with affordable housing of all forms is iChip and not the bad building strategy. The bad building strategy is one small short to medium term piece of a much broader medium to long term plan. We did have other criticisms also of the bad building strategy. Parts of it, Chairperson, do seem to recycle, rehash failed practices and approaches of the city over the last 30 years. Even the name, Chairperson, is identical to the 2009 bad building strategy of the city. But the emphasis on it seems to be, again, inspections, raids, evictions, rather than affordable housing provision and the provision of basic services. It's very light on those. It does reference iChip and say that iChip is being implemented and reviewed. But going back to our earlier submissions on the paradigm, it seems to again flip back into this hijacked buildings paradigm rather than what is needed to provide affordable housing in the inner city over the medium to long term, including short-term emergency needs. So that, at a general level, would be our set of criticisms. We also had a specific criticism that the bad building strategy doesn't provide for community engagement. And Chairperson, Commissioner, you will recall that we took Mr. Makula to this in cross-examination. There are certain scenarios set out in the strategy with steps to be followed, a step-by-step approach, and nowhere in those steps is there anything about talking to residents. Instead, it's inspections, raids, eviction proceedings, provision of TEA. And some of those steps may need to be taken, Chairperson, but it is absolutely crucial in our submission that there be community engagement if we are to achieve anything different over the next 30 years to what has been achieved so far. So, Chairperson, those are our submissions on iChip. It was validly adopted. It is the current policy of the city. It is due for review. It is an appropriate starting point for that review, including in relation to costing and affordability. If I may then turn to the ESP, which is the second main issue in dispute. And again, Chairperson, there has been some movement on these issues as we've gone through the proceedings over the last year and a half. There has been resistance on various grounds to providing basic services to residents living in buildings in the inner city that fall under the terms of reference. Initially, that resistance was the people are not registered. They don't come forward. They don't step forward and register under the ESP. Mr. Mahlangu's supplementary affidavit confirmed that in 7 buildings, large proportions of the residents, over 370, had registered under the ESP. So they had taken that step themselves to say, we need the benefit of these free or subsidized services. We're putting ourselves forward to register. So that objection about not registering seems to have fallen away. We've then faced a series of different defenses, objections to providing basic services to the people are not account holders once registration falls away, to the lack of meters or infrastructure problems, practical problems. And Chairperson, there have been 2 dimensions to that resistance. The first is that in terms of the ESP itself, these are barriers. And the second, which ultimately became the fallback and is probably where the debate ends, is that it's actually just a practical problem. It's not about the ESP itself. Chairperson, the ESP appears in the policy bundle at page 543.1 onwards. I don't propose to take the Commission there now. We did so repeatedly in cross-examining the city's witnesses. And the key features that came through, Chairperson, is that the ESP include the following. First, the ESP is the city's attempt to give effect to its constitutional obligations, which it accepts, to provide free or subsidized basic services to people who cannot afford them. So that is what the ESP is intended to do. It's intended to get those services to the people who are entitled to receive them. The ESP talks about the context and a legacy of lack of basic services in the city, and how that's a particular challenge in informal settlements and in the inner city, referring to high-rise buildings. Chairperson, far from making being an account holder a requirement, the ESP emphasizes that steps must be taken to provide its services to non-account holders, and it does so repeatedly. References to non-account holders need to be provided with basic services. So it's not the case that you need to be an account holder in order to qualify in terms of the language of the ESP. In fact, it's explicit. It says, as the city, we need to be reaching account holders, and we need to take steps to do that. It also accepts that those are many of the people who are not currently being reached. The final feature that we would emphasize is that the ESP in its terms says that it must be reviewed periodically by the city in order to make sure that services are reaching the people who need them. So there's that commitment built into it to review it periodically. Chairperson, what we would then refer to in this regard is, I'll just check that and I've made the point that the ESP refers to the need to reach informal settlements and high-rise buildings. Chairperson, we would then refer to the evidence of Mr. Makola on this issue. And we'll come to the evidence of Mr. Kosa, because the response from the city was, well, Mr. Makola is not the expert, Mr. Kosa is. We'll come to Mr. Kosa. But dealing first with Mr. Makola, and Chairperson, the relevant extract is the transcript at page 1506, line 14. And I wonder if that could be put up on the big screen. 1506 at line 14. Just reach the, I'll just come to the relevant part. Chairperson, this is Mr. Makola under cross-examination, and we were dealing with the issue of the ESP. And Chairperson, by this stage we had dealt with the fact that the term commercial building doesn't appear anywhere in the ESP. It's not a requirement or an exclusion, that there's no language in the ESP that says account holders only can receive services. In fact, the ESP says the opposite. Account holders must be reached. We're now coming to, well, what are the problems? And at line 14, I put to Mr. Makola, would you accept that the ESP is not currently reaching a large proportion of the most vulnerable residents of the inner city that it is designed to reach? And he answers, we agreed, Chair, and we raised it in our statement. Even in my evidence, I did indicate that the reason why we are looking at alternative ways is because the current ESP does not extend to a lot of people that we want, irrespective of the inner city, but across the city of Johannesburg. And I made the example about we have 5.8 million people in the city of Joburg. You only have 18,000 people registered on the ESP. It does not, he continues, it does not make mathematical sense or statistical sense that 5.8 million people, you only have 18,000 people who are either indigent or cannot afford. And again, the argument about it, if you move into the informal settlements and you look at the number of households and people in the informal settlements vis-a-vis the 5.8 million population, again, you will see that mathematically and statistically it does not make sense. So there is a problem somewhere that we need to resolve. And we identified what the problem is, and we have issued clear instruction on how to resolve that matter so that more people can benefit, including the residents in Region F. And we asked for clarification. What instruction have you issued to address the issue? And Chairperson Mr. Makola responded at 1507, line 12. We did indicate, Chair, that the policy as it stands must be reviewed. And he refers then to allocations that are made by National Treasury when they allocate the equitable share because that process takes into account the total population, the poverty index, and it takes into account people who cannot afford from a national database. So he's talking about the need to review the funding for the ESP. But Chairperson, we then continue, well, we're trying to explore why are people not, what are the barriers to people accessing basic services? And on page 1507, line 22, we're still continuing. Oh, I'll read it to the Chairperson. I put to Mr. Makula, would you also accept that the city has an obligation to assist residents who come forward and ask to benefit from the ESP to access the benefits, that the city must proactively assist them? So what was put to him is, if residents step forward and say, we want to access the services in terms of the ESP, would you accept that the city has an obligation to assist them? And Mr. Makula responded, we accept that, Chair, and we have done that. So he accepts that obligation. But what we get to, Chair, ultimately in this exchange is, well, what is the solution, the practical solution? After a debate about the challenges to do with metering, that there's a bulk meter in each of these buildings rather than individual meters. And Chairperson, we deal with that solution with Mr. Makula in the transcript at page 1568. And if we could please go there if we have it. And so, Chairperson, this is an exchange between myself and Mr. Makula around people who have qualify in terms of the criteria of the ESP but are not getting it today. So he's already accepted that there are many such people who would qualify, but that they're not receiving it. And we're engaging, and it's his testimony on the possible solutions. If I could refer the Commission to page 1568, line 5. The language beginning, I think the earlier suggestion. And there Mr. Makula testifies, I think the earlier suggestion you made, that they would have to formally apply through the city, through an association. And of course there must be a legal process and a contractual obligation that the city must know that from here moving forward, we are now engaging with the residential property, with the association of the occupants, and that it is the contractual obligation we have, because there is a possibility that even after you do make that arrangement, that they may also default and not pay. And the city must then have recourse. So in the absence of an official contract, you may not even extend those benefits, even if they may qualify for that. And so what Mr. Makula is referring to here is an approach where an association of residents or a residents committee conclude a contract with the city for the provision of basic services, in particular electricity, we would be concerned with here. And he, as we would understand it, is accepting in principle that that would be competent, but that there must be a contract. He emphasizes there needs to be a contract in case the residents don't pay and we need to go back. If we could please keep the transcript, we're going to continue. The exchange continues. I respond to him that I understand that and say that if this approach proved feasible and could be replicated across the buildings, I put it to him that that would have fiscal benefits also for the city, because those residents who are currently in large numbers not paying would now be paying, even if at a subsidized rate. And they would be making an appropriate contribution to the city, taking into account the ESP. And I ask, would he agree with that? And Mr. Makula responds, it's certainly an option we would have to look at, Chair. I do not think we are at this point. We would look at every option that is viable and that is possible, and administratively we are able to execute it. I do not think we are indifferent in looking at that as an option. So he expresses, as we would understand it, openness to replicating that option of contracts with residents through their committees or associations. I then finally put it to him on page 1569. Could go over the page to 1569. I'll read it, Chairperson. I put it to Mr. Makola that this option that we, he and I, have been developing together is also consistent with the city's own policy. The ESP is meant to reach the people that it is directed at, but the city also needs to be responsible around its fiscal position, and both those things can be achieved. The city's policies can be enforced if buildings are able to enter into arrangements of this sort through residents' associations and pay what they ought to be paying, taking into account the ESP. Would you agree with that? Mr. Makola's response, yeah, we agree. I think I did agree that it is an option to look at. It is not an option that is currently available. This is his testimony. It's not an option that is currently available at the moment, but of course it's an option that we are willing to explore, and of course it will benefit everybody involved, and we would certainly look at that. Chairperson, as I'll show in a moment, Mr. Makola is wrong on the facts that it's an option that's not currently being deployed. It is, and I'll refer to that evidence in a moment. But if I can sum up where that exchange with Mr. Makola reached, and it was important with respect to deal with it in some detail, was to put to him, first of all, that the ESP is meant to reach a far broader group of people. And in fact, he gave more detail on that, including figures of the large numbers of people that it is meant to reach, but it's not reaching. And that one option for doing that is concluding agreements between residents' associations or committees, building committees, and the city. And by doing that, the city would achieve some recovery, supporting its fiscus, but people who qualify would also receive the subsidies and rebates that they're entitled to. And we would sum up Mr. Makola's evidence on that as being open to it in principle, not raising any particular objection if it can be achieved. And a commitment, importantly, to reviewing the ESP in order to achieve that. So Mr. Makola was open to a review of the ESP to implement it in this way with building committees. Chairperson, we then come to the evidence of Mr. Kosa from City Power.
Yes.
And Chairperson, the response from the city to our heads of argument was that, well, Mr. Makola is not the expert. He sits too high on top of the ladder to have a view of how...
He's the boss.
He's the boss, and he doesn't understand how things really work day to day, which is probably true of many of us in leadership positions. It's the person closer to the ground who understands. And Mr. Kosa certainly was a witness with detailed knowledge of City Power's operations. And we dealt with this with Mr. Kosa too. And Chairperson, again, the exchange followed a similar trajectory. There was some reference, and again, it was similar with Mr. Nkwane. We dealt with the questions of commercial buildings and that there's no such thing in the ESP. We dealt with the fact that you don't have to be an account holder under the ESP. And in fact, the ESP says it's meant to reach non-account holders and they should be prioritized. What we came down to with Mr. Kosa were really the legal and practical impediments to doing what we had discussed with Mr. Makola. And we would refer in this regard to the transcript at page 1921.
One.
1921. Chairperson, sorry, Chairperson, it's line 18, or perhaps line 16. It's where, Chairperson, I begin by taking Mr. Kosa to the ESP, or to part of it, at page 543.16 on the transcript. And I take Mr. Kosa there, and we're dealing with the question of who the ESP is meant to reach And I put this passage on page 1922 of the page, at the top of the page, to Mr. Kosa. The ESP program thus enjoys priority. Sorry, I'll continue reading it and we'll come back to the text, hopefully, if we can put it up. What I put to Mr. Kosa is this part of the ESP. The ESP program thus enjoys priority and is aimed at ensuring that poor and vulnerable households gain access to the package, maintain access to the package, targeting the poor and targeting non-account holders. And so I deal with the issue of non-account holders, and I put it to Mr. Kosa on page 1922 that non-account holders qualify and that the city is required to provide them with access to basic services. And I then put it, crucially, we have the transcript back, on 1922 at line 7, from line 7 onwards, Chairperson, I put it to Mr. Kosa that City Power's approach of only engaging with account holders is inconsistent with this obligation under the ESP to provide basic services to non-account holders. And I put that to him squarely at from line 16 to line 19, that the ESP has an objective that non-account holders should receive the benefit and that it's inconsistent to only engage with account holders. Chairperson, Commissioner, you'll recall that Mr. Kosa's evidence was we only speak to account holders. It's only if anyone else comes to our offices, we send them away to credit control. We only deal with account holders. And so that's what we were dealing with. And Mr. Kosa, this is Mr. Kosa's response from line 20 to line 22. He says, yes, yeah. So I think I still maintain the earlier submission to say at least there should be an infrastructure from City Power point of view to enroll it. So where we've got to, Chairperson, is he now seems to accept that there isn't a barrier under the ESP, but he says the problem is infrastructure. And Chairperson, this then comes to the question of the legal framework and the practical impediments, which are the next two aspects that we deal with Mr. Kosa. And there was reference to this earlier from my learned friend, Mr. Semenya, that, well, what is the legal framework to allow occupiers through associations or committees to conclude an agreement with the city? And we deal with that, Chairperson, from page 1928 of the transcript with Mr. Kosa, from line 10. So, Chairperson, what we deal with here with Mr. Kosa are the standardization of electricity bylaws, which are a set of bylaws of the city that provide a general framework for the provision of electricity services in Johannesburg. They provide the key legal framework. And I first confirm on page 1928 that Mr. Kosa is familiar with the standardization of electricity bylaws. He confirms that he is. And then I take him to section 3 of the bylaws. And we do this at the foot of page 1928, from line 22. In fact, from line 17, where I say to Mr. Kosa, I want to take you to section 3 of the standardization of bylaws, and in particular section 3.1, which speaks to a consumer's agreement. I take him to the relevant page. That page reference, Chairperson, for your notes, is the reference in our bundles. It's page 1372 of the policy bundle, which is the standardization of electricity bylaws. And Chairperson, crucially, Section 3.1 is quoted at the top of page 1929. It's accurately quoted there. It provides as follows. No supply shall be given to an electrical installation unless and until the owner or occupier of the premises or any duly authorized person acting on their behalf has concluded a consumer's agreement in a form prescribed by the council. So, Chairperson, we were dealing with the very issue that my learned friend Mr. Semenya raised earlier, and I think Mr. Sidumedi also made reference to it. What is the legal basis for an agreement between residents through a committee or association and the City of Johannesburg if the owner does not come to the party? If the owner has either abandoned and disappeared, or the owner is unwilling because perhaps the owner is in dispute with the occupiers. Is there any legal mechanism? Can it be done? Or is the only route through the owner? And Chairperson, Section 3.1 is explicit. It provides for a consumer's agreement to be concluded by the owner or occupier, or a person duly authorized acting on behalf of either the owner or occupier. In other words, an occupier or their authorized agent can conclude an agreement with the city, a consumer's agreement. And, Chairperson, we put this to Mr. Kosa. There was then a brief objection from Mr. Sidumedi on the remainder of page 1929. What we put to him is it is legally competent for the city, in terms of Section 3.1 of the bylaws, to conclude an agreement with occupiers through their association or a representative committee. And after the objection, there was, or arising from it, Mr. Kosa at the foot of page 1929, line 23, refers to, well, the category of occupier then needs to be used. So he asks this question, well, what does occupier mean here? And the suggestion was, from the, at least from his earlier answer, that illegal occupiers must be excluded. This must mean someone who's lawfully renting the building, not an unlawful occupier. But, Chairperson, occupier is defined in the standardization bylaws. And we quote this definition, it appears in the transcript at page 1930, if we have that page, over the page. It's defined, and the definition, Chairperson, for your notes, appears at page 1371 of the policy bundle. It's a short definition, simple and straightforward definition, and it appears as quoted, occupier under the standardization bylaws means any person in occupation of premises at a relevant time. So it's not qualified in any way, it's simply a person in physical occupation of premises. So, Chairperson, we put these provisions to Mr. Kosa, and I won't take you through the remainder of the transcript. What we put to him was Section 3.1 of the standardization bylaws is clear. It provides that the city may conclude a consumer's agreement with either an owner or an occupier or their agent, person acting on their behalf. And that occupier is defined to mean any person in occupation of the premises. And so, not only is there no legal impediment to this kind of agreement, in other words, there's no provision anywhere in our law that says this must not be done. To the contrary, the city's bylaws actually provide for it. They create a framework for precisely this kind of consumer's agreement between the city and occupiers or their representatives. And, Chairperson, when we put to Mr. Kosa effectively that this is competent, and he had no further comment. He basically said it went beyond his knowledge. He suggested that, and we would sum up here, without the authorization of the owner, the city would not engage you. So he said, regardless of what the provisions say, our current practice is we wouldn't deal with the occupiers. if the owner is not involved. That seemed to be his suggestion. The remark wasn't further explained. So, Chairperson, where do we reach then in relation to this issue? Bearing in mind the range of objections that had been raised and have been dispensed with as we moved along. First of all, that people are not registered. Well, actually, the evidence is that a significant proportion of occupiers do go to the city's offices, register under the ESP, but don't receive the services. Then the account holder objection. It's clear from the terms of the ESP that non-account holders not only qualify, but they're meant to be prioritized under the ESP. Then the problem of, well, how do you do it if there's only a single meter? How do you divide it up? And the solution is put to the city's witnesses that you can have an agreement between a building committee or a residents association with the city, a consumer's agreement, to receive these services, including the ESP benefits, to pay for whatever remains, and it would be for the occupiers among themselves to work out what shares they have to pay for. And Mr. Makola accepts that would be an option in principle. Then we move to Mr. Kosa, who says, but what about the legal barriers and what about the infrastructure or the practical barriers? And we deal with the legal barriers with him through the standardization bylaws, Section 3.1 and the definition of bylaw, just of occupier. Those two key provisions, which make this not just legally possible, but actually an option that has been built into the framework. Chairperson, we submit that at the end of all of that, it is clear that there is no policy, legal, or practical impediment to providing basic services under the ESP to residents of inner city buildings. And to take it one step further, Chairperson, the evidence before this commission is that that has already been done and is happening in 3 of the buildings that have been inspected by the commission. And Chairperson, those 3 buildings, and I'll just provide the references. This is all to Mr. Mahlangu's statement, his original statement.
Yes.
Yes, and it's 3 buildings, Chairperson. The 3 buildings are Manhattan Court, and the reference is page 863 of the SERI bundle, witness bundle, page 863, paras 56 to 57, where it's explained that Manhattan Court, the residents already have an arrangement like this with the city, where despite there being a single meter, they collectively pay the city through their representatives. And then similarly, the second building is Argyle Court. That appears at page 870, para 108. I must make one comment about Argyle Court, Chairperson. The evidence leaders determined, and effectively we all agreed with them, that Argyle Court does not fall within the terms of reference because it is owned by a sectional title. But it was one of the buildings that was initially looked at. So we have evidence on it, but we then concluded that the city should, the commission should not make recommendations on it because it's outside the tight scope of the terms of reference. So that's Argyle Court. The third building, though, Chairperson, is Koch Mansions, and the reference there is page 876, paragraph 144. And Chairperson, the evidence of Mr. Mahlangu is the same in relation to all 3 of these buildings. These 3 buildings have managed to conclude consumers' agreements with the city and are receiving electricity through that. They are paying for it. They make their own arrangements. So, Chairperson, just to explain practically, perhaps in the last couple of minutes, if the Commission does intend to adjourn at 4, how this works, because it is practical. It is already being done at 3 buildings. And we've made the submissions that it is contemplated, provided for in the ESP, and provided for legally in the standardization bylaws. But how does it work practically? There is a single meter in many of these buildings. the system of the ESP is per household subsidies or rebates. So each household has to apply. If 50% of the household qualifies, meets the ESP criteria, the whole household is entitled to receive ESP benefits. And those benefits are determined by poverty level, by income level, under the ESP categories. So what you would have, Chairperson, is that individuals register under the ESP, as they have been attempting to do. They are then entitled to receive, per household, that amount of a rebate. And let's say that in a building there are 100 households overall, and 50 of the households register and qualify under the ESP. The city would then simply process 50 rebates of the appropriate level. It's a straightforward tariff processing exercise, the same as the city does for every other household where people are registered under the ESP. There are 50 households registered. You would just reduce by that amount the amount owing. In other words, you would deduct those rebates from the total amount. There would then still be a total amount owing each month. It would be for the residents, the 100 of them, to develop an arrangement among themselves where they work out what their shares are to pay the city its full dues. What is the outcome of all of this, Chairperson? The outcome for the residents is that those who should qualify for basic services will receive them. The outcome for the city is that it will get paid. And it will get paid what it is meant to get paid according to its own policies. The full amount due for the provision of electricity, less any acknowledged, approved ESP subsidies or rebates. So what we would actually achieve, Chairperson, is the ESP and the city's credit control and other bylaws working as they are meant to work. People pay for what they consume, less what they're entitled to as a subsidy or a rebate under the ESP. What we have at the moment is that there's just a closed door to people receiving the basic services. And that closed door is unjustified by any reason in policy or law. What we're left with is this idea that it's not practicable. But we see it is practicable, and it's already happening in 3 buildings. And there's no reason on any evidence before this commission why that cannot be replicated for every one of the inspected buildings where basic services are currently not being provided, and every other qualifying building in the inner city. The problem of doing the divisions within the building and among the residents will be left to the residents of the buildings. And yes, that's a challenge. And yes, it will require functional committees, and functional committees that engage well with the city. But that's a healthy outcome. It's a good outcome for the buildings. It's a good outcome for the city to have responsible residents' committees that are determining what is due to the city from their residents and paying it across each month. It's effectively a win-win outcome, Chairperson, and it's a win-win that achieves constitutional imperatives. Chairperson, those are our submissions on the ESP, and we have dealt with the 2 core issues of ICHIP and the ESP. What remains for us to deal with, Chairperson, are our proposed findings and recommendations. And Chairperson, that we envisage not taking all that much longer. We've dealt with the real meat, but we need to come to the practical solutions.
Yes.
Chairperson, if it is appropriate for the Commission, I see that it is 4 o'clock.
I think it will be an appropriate time to adjourn and reconvene tomorrow at 10 o'clock.